onwards, my lord. Though otherwise I'm ready, my lord. Whether my lordship will take it up, it's a bench free matter, my lord.
Is it parted before this court?
Not parted exactly, not parted.
Then it has to go before the bench. In item number 2
2 to 7, my lord.
to 7. Mr. M. Datta, learned counsel, learned amicus curiae appearing for the petitioners as well as the learned standing counsel, finance department. Mr. P. Nayak and Miss M. D. Bora, learned SCW, IWP submit that these writ petitions pertain to civil bench 3. And therefore it has been wrongly listed before this bench today. Taking note of the submission made at the bar, registry is directed to verify and leave these matters before the appropriate bench.
My lord. Diploma.
May I, your lordship?
Yes,
Lordship, in item number 9, we have filed a rejoinder affidavit in reply yesterday, lordship. May I be permitted to bring it on record?
yes.
Lordship.
May I please, your lordship? I beg to mention for listing of a fresh writ petition filed yesterday for tomorrow.
What is the matter?
The matter pertains to settlement of HAT. Initially, the NIT was issued by the Jorhat Jilla Anchalik Panchayat for settlement of 14 numbers of daily markets.
You go to civil bench 4. It is a bench 4 matter.
Yes.
My lord, I'm paying for listing of a writ petition for motion for tomorrow, my lord. I am challenging the recovery proceeding initiated by the GST department, my lord. They have freezed my account, my lord. After I have referred an appeal, my lord, I have made a pre-deposit. There is a record.
May I please, your lordship, my lord, in connection with item number 15, my lord, a miscase has been filed already registered, my lord. The same may be called for to bring on the records today. Item number 15, my lord.
All right.
Obliged, my lord.
Oh, it is the IA. IA cannot be brought like this. It has to be listed.
But it has been registered, my lord, already yesterday.
All right.
Already registered, my lord.
Mr. DP Bora, learned counsel for the respondent submits that an IA has been filed in this writ petition on behalf of his client, but the same is not on record. Since the IA has already been registered, have you informed the other side?
No, I am not mentioning, I am not praying for adjournment, my lord.
Then let it come. IA cannot be brought by a slip.
Yes,
Sorry, that's not possible.
obliged, my lord.
IA has to be listed.
May I please, your lordship? My lord, kindly allow us, may I please, your lordship, we want to mention for listing of matter, 2 matter for tomorrow, my lord. There is an urgency, my lord.
What are the matters?
Matter is where your NF Railway will encase our money with at any time, my lord.
What money? Bank guarantee.
Bank guarantee, my lord.
Bench 4.
Bench.
May please, your lordship. Already your lordship had at length in the other matters, my lord, and I will not take much time, my lord.
No, it's all right.
Only, my lord, I'll just after the judgment, I'll place, my lord, which shall not been argued in earlier, my lord. After the judgment passed by Honorable Justice Jain Sharma, when the set aside the, my lord, select list, and then thereafter there is a appeal, my lord. In that appeal, my lord, already that judgment was laid out. After that, my lord, in compliance with the order, they passed a order. After the division bench judgment, the page 69, your lordship kindly see, my lord. Page 69, my lord.
Achha, before that, Mr. Mohanta, let us see what is the prayer of the petitioner in the writ petition.
Yes, ma'am. I'll also come to that, my lord.
This writ petition was filed in 2010
Yes,
and the selection process pertains to year 1995,
95,
15 years back.
my lord. No, my lord, this petition was filed earlier to that, my lord. There is another writ petition filed by me. In that writ petition, my lord, I questioning that, my lord.
That was in 2006.
2006. So
This
we
11 years after the process.
exactly, my lord, 11 years after the process. So then I, in that writ petition, I claimed some that some information was not given by the authority, and then this honorable court says that there is a appropriate forum, you can file RTRO, and that And regarding other part, my lord, already government has taken a decision that they will make an inquiry. That was the judgment passed in my earlier.
In the first writ petition, your client merely wanted an inquiry to be conducted.
And also what happened to the advertisement and pursuant to the court direction they published. Because I was the aspiring candidate of that advertisement, my lord.
Yes,
After the final, after the first judgment, writ petition judgment, they, my lord, published a advertisement. I was the candidate of that. So then, my lord,
just a minute. You were a candidate of the advertisement published after the first judgment.
earlier also I was selected.
Hmm.
I am a selected candidate.
Hmm.
I am a selected candidate whose list was selling before this honorable court.
You are amongst the 150,
My lord, my position is 80, in serial number 80.
right?
So since it is set aside by the High Court, so I keep mum, my lord. Then,
Whether the select list was set aside or not, we'll discuss about it little later. This court may have some reservation on that.
no, that point of time, till that point of time, it was, because against that, my lord, there's a writ appeal. There's a writ, and in fact, that was the consent order. Although,
No, Mr. Mahanta, let us put the debate in the perspective.
My
Let
lord.
us put it in the framework. Your client was one of the applicants who had responded to the advertisement notice of 1993,
my lord,
right? Then some people were appointed as extension officer.
my lord,
Your client was not appointed.
not appointed.
So the unsuccessful candidate, they approached this court by filing a writ petition.
No, my lord. Successful candidate of the, my lord, that select list, my lord, but they are not appointed.
All right, people who
They
are not,
oppose this honorable court, although they are selected, they oppose this honorable court stating that there's a illegality on this, my lord, selection process. That's why that was in, on their pairs, it was set aside. Now, my lord,
what was set aside?
the
What-
selection process.
Where is it? Let us see that first part. Where is the order setting aside the selection process?
May I read the judgment, my lord?
Yes,
My lord, page 54, my lord.
yes, page 54.
All this, there are several writ petition, my lord.
Hmm.
About
So
six.
you may come to the relevant part.
Yes,
The-
para 6, my lord, page 55.
Hmm.
Para 5 is also 11, my lord. It is needless to say that those persons who have been victim overage and filed a representation before the authority for necessary age relaxation with the application and authority shall consider the relaxation age also in order relating to ensure. It may be stated that herein that the in concern order the authority on basis of the inquiry report fairly considered that the earlier selection and appointment on the basis of the such selection are all illegal and arbitrary, and such both the parties agreed for fresh advertisement and section and selection and indicated above in civil rule number 234/96 there was a private exponent but no one appears on this appeared for him. It is selected list suffered
All
from
right,
cross
all right, all right. Now,
7, para 7 is important.
Mr. Mahanta, apart from other things, with all respect,
My lord.
the order passed in order that you're reading
My lord,
says it is a consent order.
my lord,
Persons who were not selected
my lord.
and the department, they can't consent to an order setting aside selection of the appointments of people who are not before the parties.
My
So
lord, I agree.
therefore, technically, we will not take
Yes,
it. as-
I understand. But at that point of time, it was law, my lord. It was because in pursuance to they issued advertisement, my lord. In pursuance to this, my lord, they issued advertisement 2002.
Hmm.
And against that, my lord, there is a writ appeal. Writ appeal also not interfering, my lord. Writ appeal also says that, my lord, but you
writ
take
appeal-
action by issuing notice,
It will not interfere, but as you open up your argument,
my lord.
I feel it necessary to flag a few issues here so that when you argue, you can address it. Right? You see, the learned single judge says it is a consent order, the selection is bad.
My lord,
Why is it? There was an inquiry conducted by someone in the department in 1996. And he has come and made a statement that this is all irregular. Why irregular? What irregular? Nothing, no finding,
My-
nothing. Then the learned judge, I'm not being critical about the judgment, which I cannot. But I will only agree with the judgment to the extent it is legally permissible,
My
not
lord,
beyond that.
exactly.
That part I will obviously deal with. Now, the persons who were not appointed came to the court saying that I was not appointed, so there is irregularity in the appointment process.
My lord.
The department came and said, yes, the whole thing is irregular. Why irregular? What is the irregularity? What is the material? Nothing. There is no reference. And then the learned judge said, it is a consent order. So the whole process is illegal. Issue fresh advertisement. Now this raises three questions, which I will request you to address the court as you argue. First of all, there can't be a consent order between two parties, leaving aside the beneficiary of the order. Question doesn't arise. So this is not a consent order. If it is not a consent order, then the court will have to see what is the basis to declare. It could be a collusive order also.
My lord.
It could be an order in collusion also. Some petitioners come and some government officers come and say whole thing is illegal. That is what is the meaning of collusion.
Right.
Be that as it may. The division bench says, don't be influenced by the finding
My
of the single judge. Serve notice, hear them and take a decision. Otherwise, we are not interfering. So here also, I would like both sides to address the court. This is the main issue. That issue has been changed and the division bench says we are not interfering.
My lord.
The learned judge says everything is illegal, throw them out, issue fresh advertisement. Division bench says don't do it. Issue notice, hear them, and then take a decision. Don't be influenced by the order of the single judge.
My lord.
Correct. That means the division bench says the single judge's observation is obliterated, which would mean that the process is illegal. That part is obliterated. Otherwise, what is the need to hear?
Absolutely, my lord.
So therefore, in my opinion, this division bench has interfered with the judgment of the single judge.
Correct.
Regardless of what
agree,
is-
my lord. I am not on that now.
No,
My lord.
can I just,
My lord.
otherwise, you see, you will argue and then you will come back to point number one and again have to start afresh. Because what will happen is, if I make these queries later on,
My lord.
then you will find that your whole argument has gone in another direction and the matter will have to be adjourned for another day, which I don't want. You have been putting in a lot of effort. I am trying to see if relief can be granted.
My
to
lord,
the
exactly. I confine my argument to a very small passage, my lord. Now I'll place before you.
Therefore, these issues are relevant. A person has been fighting a case for decades together. To tell him that, sorry, you are not entitled to relief, the court has to be absolutely sure. Therefore, your response will be required on all these points. Now, notices issued. Even at the stage of division bench, he is not involved in the proceedings,
Right.
your client. Fresh advertisement issued, even there your client is not involved.
Involved.
It is-
He applied.
He applied, but he came to the court only in 2006
My lord.
for the first time,
My lord.
saying that what is happening, I don't know. I don't know, there is no transparency. How they are conducting the process, etc. Please let me know.
Right.
The learned judge says, you make an inquiry on the RTI Act and get the information.
Then I
Right,
got the information.
correct. You got the information. Then you filed this writ petition in the year 2010.
Right.
Now, what is the prayer in your writ petition? Let us proceed sequentially and see what are the developments.
Page 22, my
What is the
lord.
prayer?
Page 22.
Page 22. First, institute an inquiry.
Institute an inquiry by an independent investigating agency, fix a responsibility of the person who have appointed and allowed the illegal appointment of a contribution till the like the industry.
Alright.
To issue a writ in the nature of Manna having a respondent to disclose the what steps have been taken under the fill up the vacant post of the extension officer under the direction of the industry.
Right.
Advertisement.
And the fourth prayer is to appoint him.
My lord.
Now,
So now,
to appoint him on the basis of which process? appointment has to be made on the basis of some process, is it not?
My lord,
Which process?
process, my lord, that as per select list, who are my below me, my lord appointed.
Right. So he says these are all illegal,
No,
institute an inquiry, and in the meantime appoint me on the basis of. Is it not a mutually contradictory prayer?
That's why I'm leaving aside that I am stick to 94 para number, my lord, my prayer full, my lord. Because already your lordship has, my lord, in here others matter, my lord. I am submitting before your lordship. Your lordship kindly see. And they have, in RTI application supplied the document to me, I came to know that 6 of the persons, they are below me, they were appointed because they opposed this honorable court. That was the reason they were appointed. And some of the persons who are not even, my lord, selected, they are also.
Therefore, your case is some people have been appointed for reasons which are not legitimate.
Exactly, my lord.
Therefore, appoint me also for reason which is not legitimate. Is
No,
that
my
your-
lord, if, my lord, the person who are below me were appointed,
Hmm,
see, so long their appointment is continuing,
hmm.
then I have a right because that select list, that means you are pursuing that select list. That means on the basis of that, because how
They were appointed when?
they were appointed in 2001, my lord,
2001.
one.
Now you come 9 years later.
My lord, that I came to know when in 2006, my lord. Because when RTI application was given to, information was given to me, then I came to know.
Hmm.
I made them party. The selection, but that lead petition was, my lord, in fact, in that lead petition, my lord, there is an inquiry by the chief secretary was produced. Then lead petition was allowed. Then, my lord, some person who are not even the, my lord, party to the proceeding, my lord, they approached the honorable the division man stating that we are not a party and that chief secretary's report, if it is acted upon, then we will be in the difficult. So in that situation, my lord, that is again remand back, not only in last occasion, my lord, of course, it is not made a party, it is not a correct, my lord, on not that ground, it was set aside, in other grounds also, it was set aside and remand back to my lord. And then 2014, when it was remanded back, and thereafter, my lord, this honorable court, my lord, asked them to file a detailed affidavit regarding, they give a impression that we are trying to consider his case. So in 2017, they are giving assurance before this honorable court. That is why it is, my lord, pending, and that is now it is this stage, my lord.
Hmm.
So my submission before your lordship, yes, if the person who are selected in below me, if they are continuing, then definitely, my lord, I have a right to appoint, my lord.
No, you may, but then, or alternatively, the court would have set aside their appointment.
My lord. No,
But then,
if set aside the appointment, their appointment, then, my lord, I have no case, my lord. Then I am not paying for any inquiry, my appointment, my lord. I cannot even.
Hmm.
But if so long they are continuing, I think that is my opinion, that I have a right to, at least I have acquired a right, because the person below me are, my lord, appointed, and I am not, my lord. So, my lord, that is
But,
my.
have you challenged their appointment? Are they party in this?
Yes, they are party. They are very much before your lordship. No, what happened, my lord? There are 6 persons I have made party. Then, my lord, some other person who made a lead appeal, then the honorable division bench, my lord, asked me to implicate those persons who opposed the division bench. I made them also party, my lord. They are not even selected. They are selected, but probably some are not selected. I don't know, my lord. Just because of the division bench order, I made them party. But our original 6 persons who are below me, they are originally in the representation, they are party. They are before your lordship, they are representing my learned friend, my lord.
So in other words, your case is founded on negative equality. That if you have illegally appointed some people, also illegally appoint me. Is that the case?
No, negative equality, I am not paying that, but if your lordships, if negative equality is also, my lord, equality, we have to see in the Article 14 also, my lord. Because person, my lord, they are continuing, and if they set aside their appointment, I am submit before your lordship, I have no case. But if so long they are continuing, I think that I have a right. That is my case, my lord. That's, my lord, that if is that judgment also, my lord, prevail on that situation, my lord. When there is a right, there is a remedy, my lord. So at least, my lord, your lord,
Your serial number, what?
my serial number, I'll place this. Your lord,
80.
kindly come to the, my lord, select list, page 26, my lord,
Yes.
page 26. page 26, my lord. This is the select list, my lord. My serial number is serial number 80, page 27. Start from 26, page number 27, my lord. My serial number is 80. Tilok Nath. And respondent number 9, serial number 96. Respondent number 6, serial number 99. May I read their position, my lord? Respondent number
Yes, they are all general category candidates.
yes, they are all general candidate.
So why did you not approach the court at that point of time?
My lord.
Why did you not ask for a
Lord,
direction?
these are the document I came to know, my lord. Those persons who are below me were appointed. I came to know in 2000, my lord, after getting the RTI application, my lord. After getting the RTI information, my lord. That's why, my lord, I am delaying opposing this honorable court, my lord. That is my case, my lord.
And what is the age of your client today?
Now at present 52, my lord. At that point of time, my lord, it was quite. Even in the second and
Can
third.
someone aged 52 years be appointed in a government job?
If, my lord, from the date of appointment of their, my junior, my lord, was in the junior in the sense, my lord, below the select list. If from the date of that, there, if your lordship appoint, my lord, then I will very much, my lord, I am in the age, my lord.
So his appointment has to be retrospective.
My lord, there, everything will be counted from my date of joining, my lord. Otherwise, my lord,
So he will join tomorrow, but with effect from 15 years back.
maybe, my lord, the person who is the junior should appointed, my lord. Otherwise, my lord, your lordship kindly, there is, I will not get any relief, my lord. Because the person, even, my lord, it is hurt me because, my lord, the person who are not been selected, they are also continuing. The person who are ad hoc, they are also continuing. Persons who are, my lord, selected below me are also continuing, my lord, except me.
Mr. Mohanto, the court very well appreciates the sentiments of your client. Sentiments are appreciated. But the fact is, the cases have to be decided on sound legal principles,
My lord.
not on sentiments, right? So therefore, that is the reason the court is trying to figure out under what principle relief, if at all, can be granted to your client. So three things come in your way. Number one, your case is apparently, whatever be the explanation, your case appears to be horribly barred by time.
I agree,
Because
my lord.
when the select list was published, then your client ought to have been vigilant and approached the court. But for whatever reason, he did not or he could not. The prayer for appointment came only in the year 2010. That is about 15 years after the private respondents were apparently appointed, after 15 years. So if the court, and it has to take the yardstick applied in the judgment dated 17/3/2004, then after 15 years, they cannot be thrown out. If that
Oh, my
yardstick is right. Number two, what is the equity in favor of or equality in favor of your client? Let us take it that persons below the petitioner in the select list were appointed, and they were appointed on absolutely wrong premises.
Long premise.
They say that since they have brought it to light,
My
that
lord.
is,
They are the
that is why
whistleblower, that's
they were
right.
selected. That's obviously absolutely preposterous, to say the least. But if they were not appointed, you would not have any right.
Exactly, my lord.
So your case is entirely based on negative equality. That is the principle,
My lord.
whether you name it or not. That if you have done something wrong to others, do it to me also, so that I also get the same benefit. That is negative equality. Now, there are decisions, time and again reiterated legal principle that negative equality cannot be enforced through a writ of mandamus. And third thing, even if the court ignores the negative equality aspect, today he does not have the requisite
What?
age qualification to enter into service. Because if you enter into a government service, it operates on some set out parameters. Somebody in a service, he has to be appointed against a regular vacancy. Where is that vacancy? Which vacancy is there? Secondly, he has to serve a minimum length of service.
Vacancy,
That
my
is the
lord,
reason
my lord,
there is a particular age cutoff,
my lord.
which is 36 years, I believe, for reserve category.
30 years, some relaxation on that. At that point of time, probably it is up to 42 years there.
42 years.
Some
So the relevant rules do not permit anyone to be
that I
recruited
agree, my lord.
after 42 years. That is because there is a minimum length of service. There will be other issues if a person is appointed, pension
38 years.
entitlement, etc. And leaving aside everything, what is the wrong done to the petitioner by the government? Supposing there was a wrong done to the petitioner, then also the principle that was mentioned the other day might come in. But then you are saying there is no wrong done to me. It is the only thing is that
No,
some other people less meritorious than you
my lord.
have been wrongfully given a benefit. So that wrongful benefit must go to you also. That's your offense. Otherwise, if they are not appointed, then you don't have a right. You are saying that. So per se, the government has not deprived you of anything. You just you sprang into action, you means your client, only because some other people situated below you have got some benefit. So if you are giving it to him, give it to me. That's the argument.
Correct.
So it is not a case of wrongfully denying the petitioner of
No,
appointment.
then my lord. Then my lord, no, then my lord, if your lordship, first my first prayer was to make an inquiry. Make an inquiry to the whole
Correct.
episode about considering whole my,
At that stage, you didn't know what was happening.
my lord.
Your client was not aware.
Don't know. So
Why he
that's-
was not aware, we will not go into it because many things have happened by then. The first case where single judges passed the order,
My lord.
that order was passed in a proceeding in 1997. So things were happening far before when your client approached the court. But at that stage, he did not assert any right. Right. This writ petition was basically an RTA application
My lord.
without mentioning it. So the learned judge says, if it is, you want information, file an application under RTA. So at that stage, he didn't have any grievance against any individual. He is only,
In fact, in that judgment, there is a direction to my lord making, because giving a assurance, if your lordship go to the judgment, and there is a. The next, my lord.
judgment is at page.
It is 11.
84. 84.
But you can, Mr. Mohanta, you can still argue your case and I will consider every argument. The
No,
court
my
has
lord, I
not
am
yet
not
decided.
trying to waste the time, my lord. My only single anxiety, I only that, my lord, so long they are continuing, my lord, I think my understanding.
So what
that
is the
I-
principle? Show me that principle.
My right, my lord,
Yes. Show me that legal principle.
because,
We'll ask them to respond and then decide the matter.
no, my lord, but admittedly, they are below me, my lord.
Correct, they were wrongly appointed. So you show me
The
the principle.
person who were wrongly appointed
Hmm,
by virtue of that select list, my lord,
hmm.
because, so person who below me were wrongly appointed, if they are continuing, and if I oppose this court,
So many-
pointing out that,
Show me the principle which supports that
so
argument.
that, my lord, definitely, I'm also, my lord, pointing out before your lordship that, my lord, these are illegally appointed, my lord. Since illegally appointed are continuing,
They were not illegally appointed. They were appointed for reasons which are not legitimate. Correct.
that also meaning,
Yes.
indirectly meaning is
Correct.
same, my lord.
But after 15 years, their appointment has been challenged.
That,
After
my
15
lord,
years.
I agree that, yes, I delay that is there, but within my domain, my lord, because your lordship, in all cases, my lord, that delay is not fatal, my lord.
Provided the
My lord,
facts.
no, my lord, if your lordship hold that, my lord, if I have a right, because
What is your right? That's what I'm
right,
asking.
my lord, so long they are continuing, my lord, I have a right, definitely. That is my, maybe your lordship not accepted my argument, my lord. But the person who are illegally appointed below me who are, my lord, they are continuing. Then, my lord, in that case, negative equality, my lord, it has to be legitimately.
No, Mr. Mahanta, you see, let us examine this argument objectively.
My lord,
Correct? Because as the court has already said, if the petitioner, any semblance of right can be recognized in favor of the petitioner, the court will be more than happy to do it. Why would somebody be denied of appointment or recruitment if he is otherwise entitled to? But then there are hurdles in this case which has to be met. Even while writing a judgment, we have to
My lord,
base it on sound legal principles. You see, again and again, as I am saying, first you have to show that by virtue of your position in serial number 80, your client would have a right to be appointed unless those vacancies were filled up by someone else. This is the first argument we'll have to establish. I don't find any pleading in
My
the
lord.
petition, number one. So I'm pointing out several grounds on which are roadblocks for your client. First, you have to say that if these 4 persons were not appointed, I had a right to be appointed against one of the posts advertised for XYZ reason. Now, only to deny me or by appointing them, I have been denied. This is point number one. Point number two, you have to say that when the select list ordinarily has a validity of 1 year,
my lord.
why did you not inquire how the select list was operated? Why did you wait for nearly 10 years before approaching the court, even with a doubt? Even with a doubt, why did you wait for 10 years? Why should the court not presume that you had given up on this whole thing? Suddenly, with some idea triggering in mind, your client wanted to take a chance. Why should we not take that view? This is number two. Because delay in the matter of enforcement of fundamental right is not a ground. But then the court will always see the facts and circumstances. When the selection was held in 95, the select lists were published in 95. Appointments are made even before publishing of the select list,
My lord.
illegally, correct? But those things have now been set at rest. Those are now set at rest. Except that the 2 cases, Mr. Chaudhary, 3 cases, Mr. NNB Chaudhary has appeared. Their grievance is that the inquiry report submitted by Chief Secretary cannot be a basis to throw them out. And there, if I remember correctly, first point was that more than 15 years. In fact, people have served for 28 years. Some have retired. Somebody has died, family pension given. How do you set the clock back now? What will you do? After 28 years, you show the door to the people. It cannot be done. There is a judgment of Mukul Saikia
My lord.
by Supreme Court. There the facts were even bad. That judgment, Supreme Court he has not cited it, but that judgment is there. Anyways, this is one aspect of the matter. The other aspect, as I said, the order by which Chief Secretary was asked to inquire, that order has been set aside by the
I've
division
seen,
bench.
ma'am. Actually, that day.
No, that
day I have
expression is
I am
not
sorry
there.
That day I have not pointed out.
No,
But
it's all right.
I have seen that division bench judgment. I have seen that, my lord, although it is not permit party, but it is not that, my lord, yet Chief Secretary is, that was the submission made by the one government advocate that will make an inquiry. In fact, there is no order also. So that was taken into consideration and finally this situation was disposed of on the
Right.
basis of that.
Right.
So-
But the division bench has set aside all
Set
the
aside
orders,
that
including
too,
their
ma'am.
order.
That I have seen.
So how can Chief Secretary make an inquiry on his own in a sub judice matter? He cannot. If he says that I did it because the court order, that court order is gone. It
That's
is
why-
non-existent.
That is
So
why, my lord, I
How
am
can,
I am not actually, I am not behind them. If there is a scope, my lord, for my appointment or have giving something to
all
me,
right,
my
all
lord,
right,
that is my case.
you are good.
So that is my only thing.
Can you appoint him?
Lordship at this stage,
No, my lord,
well,
this
I
will
mean,
become
under
a check,
what
my
law, that will be difficult, let's say.
Hmm?
That will be little bit difficult.
Little bit difficult,
Little
but
bit
not very
difficult. It
difficult.
will be difficult, your lordship, it will be difficult. Lordship, as far as like 2 points, lordship, like I think in my.
No, but have you
let-
finished,
let-
Mr.
let-
Mohanty? You,
My lord, I have finished, my lord, because I understand at least, my lord, your lordship kindly see the position because actually something are not in.
the
favor
minor
also.
sentiments, anything else, legal?
My lord, legal, your lordship kindly, if your lordship slide that again I am submitting, my lord, repeating, my lord. If they are continuing, I think, my lord, I have a right.
So show me a citation authority.
That,
on that.
my lord, that is my submission, authority on that point, because that negative will not come to that effect, my lord. the person who are similarly situated working, then Article 14 will come definitely, my lord. Because I'm above them, my lord. So it is, yes, sentiment is also there, my lord. Sentiment will not do. But my lord, if your lordship hold that I have a right, then there is a
What
limit.
is your right?
So
That's the
that, my
question.
lord,
What is your right?
directly I am finding out no any judgment, my lord, in that.
No, no, where is your claim that you have a right to be appointed? You had a right to be appointed.
On that
On what
thing,
basis? Where is the pleading?
pleadings not there, my lord. Because
Then on what basis the court will come to that conclusion?
but since there is a pair for my appointment, I made a pair for my appointment also. So that is my case, my lord, because I am lately entered in this case. Earlier I am not in this case.
No, no,
and I
that-
have seen the pleading.
Nothing
Right.
again. You are doing
Oh.
your job, Mr. Mohanto. You
So
can't
my
change.
submission before your lordship.
You cannot
was-
improve on your case. Whatever is there is
my
there.
lord.
On facts, you can't improve. Only on the,
And I am last several days my life searching, and that point, my lord, clear cut, my lord, I am.
no, even if it may not be as much as you have done. But I can assure you, even I have worked a lot on this brief to see
My lord,
what relief
I'm
can be
grateful
granted to
your
the
lordship.
petitioner.
I also
That
have,
is the reason I am telling you more than you submitted so far.
my
I
lord,
have gone through every page. Every page I have gone through. I can figure out everything you tell me,
my lord,
but
accept that EBCB judgment, but for that other,
that judgment will come in not for appointment, for compensation. If he has
Compensation.
been wrong, but his right has to be established first. His right has, it has to be established that he was one of the persons who should have been appointed against number so and so number vacancy, which is still lying vacant. He asserted his right. Authorities denied him wrongfully, and the delay is only because of pendency of litigation. If these three criteria are met, even we'll ask them to pay him 50 lakhs compensation. That's what I was thinking. Don't appoint him. Pay him 1 crore rupees compensation. Let him live in peace for next 9 years. Or pay him the salary for that period, entire period of service. But that pleading is not there. There is no assertion to that effect. How does the court come to
I
a
have seen, my
conclusion?
lord, although I am getting that appointment.
Till late in the night yesterday, I was
I
examining
also,
your
my lord,
file.
yeah, last night I also searching it. I will not find any judgment in that point. So that my case.
What to do?
No, if your lordship, my lord, something, my lord, can be done for him.
No, what is, you are
No,
a senior
should-
counsel.
No,
You,
that I agree, my lord.
you
Actually,
please
why I
assist
am-
the court.
No,
What is the right thing to do? You tell me.
no, my lord, actually,
Don't step into the shoes of your client, which you will not.
my lord,
You assist the court by giving the right guidance. What is the right way here?
actually, my lord.
Because
I-
whatever we do here will have to be done in every case, unless set
correct.
aside.
No, my lord, I was under the impression that, my lord, they have given a assurance before. the
Even the judgment in the bench headed by Honorable Justice Amitav Roy, that judgment doesn't help you. Because the last line says it will not be treated as a
It is
precedent.
precedent.
So I'm saying, Mr. Mohanto, I have gone
My lord, then I leave it
every
to your lordship.
paper
My
to
lord,
see if some relief can be
one, my
granted.
last submission, my lord, I am submitting, my lord. Actually, I am acting on their assurance last 5 years. They have given a assurance before this honorable court.
Please don't.
No, my lord, why? Because they can easily that,
They don't have the right to give assurance.
my lord, but there is a submission and recorded, there is an order. That I think, my lord, that submission have some value, my lord, because they said I will place people before I will take a decision. We all have taken steps.
Hmm.
We have taken a step to regularize all and including the petitioner for appointment. There is an order passed by this honorable court. Is a given a clear, given assurance to this honorable court.
Which order? Which
What they have done, my lord, in that case, my lord,
order passed in which case?
my lord, this case, my lord.
Which,
I-
what is the date of the order?
Yes, my lord, I'll
Then you file a contempt case.
move it today.
We'll have to deal it that way then.
My lord, I'll just give you the lordship.
What is the date of the order?
Order the 4/9/2017. Page, your lordship kindly ordered the 4/9/2017.
4/9/2017.
My lord, the respondent authority submit that they have decided to prepare a submit and fresh proposal for accommodate the petitioner as well as the private respondent in the post of extension officer so and so, so and so, so and so.
Fresh proposal.
Next order is 6/11/2017. Standing Council for the Industry and
No,
Commerce.
no, but this order was passed in 4 writ petitions. It does not refer to facts. Your client's case is slightly different from others. This observation
My lord,
cannot apply to all the cases.
no,
It
that
is definitely there
in
is
my
some-
cases, my lord, petitioner, your lordship can decided to prepare the suggestion for the petitioner as well as the private respondent. Petitioner means, my lord, that is petitioner means me, my lord. Because it is my petition, it was passed.
No, then Mr. Mahanta, please explain. In these 3 writ petitions, 4 writ petitions, minus WBC 997 of 2010, where the petitioner wanted a direction to appoint him. In 997 of 2010, one of the relief is forget the
My-
fact that it is a mutually contradictory. If technically it was the approach, then the writ petition can be dismissed in 5 minutes. This is a mutually contradictory relief. On one end, he is saying, inquire into this is illegal, irregular recruitment process. In the meantime, appoint me. Well, obviously, this is on that ground, the writ petition can be finished. But I am not being technical here for a moment. The other 3 writ petitions, they were already serving.
There is already your lordship, my lord, segregated.
Yes.
These are
So then this order cannot apply to all the writ petitions because where the petitioner is already serving, how can the learned judge observe that the
No,
assurance
that
is
now
given
I
to consider
cannot
their
offer-
appointment?
I cannot, my lord, criticize that order, but that was a order passed in my case, in the petitioner means me, my lord, in that case. Now, my lord, in different way, I cannot.
I'm sorry to say this, I
No,
wish
my lord.
the orders were a little more clear on what they actually intend.
My
This
lord.
is also generated, I'm very sorry to say. These are 4 writ petitions. In 3 of them, all petitioners are working. In another one, the petitioner is seeking an order of appointment after 15 years from the selection process was concluded. And the submission has been recorded that authorities are looking on to appoint them.
May I clarify, Lordship, what has happened?
Mm.
Actually, what has happened in other writ petitions, this chief secretary's, report was challenged. Chief secretary's report was challenged. So they were working, so they were not regularized the report. When their appointments were.
Mm.
So what has happened is that the department was, because they have spent so much of time, because around 20 years they have spent. So department was thinking that whether they can be accommodated, all these petitioners can be accommodated. So department commissioner took it on his own. And he said, he had a discussion with us also. Then he said that, like, if possible, we'll try to take it to the cabinet. And if cabinet takes a decision, then we may probably settle the whole issues. But that was the concern actually. And that is why this was stated that, like, department is working on this. If something can be done, then we'll do it.
No, but any assurance given to appoint
No
Mr.
assurance,
Mahanta?
Lordship, no assurance at all. Lordship, how can the assurance can be given just like that? There was no
My
assurance
lord,
at
I
all.
am
We
reading
only
I am
stated,
reading the order.
we
my lord.
only
Your lord- Then,
stated-
my lord, your lordship kindly, for my satisfaction, your lordship, I will read the order, my lord. That
there
is
was
just
no
your lordship
assurances.
reading.
We stated that we'll place it before the
What
cabinet.
I am submitting from my record, my lord. Yet, your lordship kindly see order dated, my lord. Order dated 3/5/2019.
3/5/2019.
19, my lord. I will read all the order, my lord.
Just a minute. 3/5/2019.
Before that, your lordship kindly 10/8 is important, my 10/8/2018, my lord.
These orders are not errant serially. 10/8
10-8, my lord.
You are referring to 3-5 or 35?
35, my lord. Before that, my lord, your lordship kindly issue the 10-8 will be important, my lord. 10-8-2018. May I read the order? Standing Council, Industry and Commerce submit a copy of this note sheet where it appears that a proposal has been made to the Commerce and Secretary Finance Department by the Under Secretary of the Government of Assam Industry and Commerce Department, for which view of the request made to regulation with service of 11 number of extension officer in the Department of Industry. Senior counsel of the petitioner submit that the SC Standing Council Commerce may be directed to obtain instructions to the where the 11 post of the which the extension officer were proposed to be regularized, including the petitioner of WPC. Your lordship kindly see including the petitioner of WPC 997 of 2010. That is the order dated on 10-8-2018. Now, my lord, your lordship kindly came to the 8-2-2019. Respondent counsel submit that he has not been able to get full instruction. He may be granted 3 weeks time. Next, my lord, on 10-5. Learned Standing Council for the Industry and Commerce Department submit that despite of his best effort, the requisite instruction has not been received by him. It is further submit that in view of the lack of instruction, the Industry Department has not been able to file any affidavit in opposition till that. In the appears that the selection process of the appointment of the extension officer under the Director of Industry in this subject matter is challenged in the present writ petition where the petitioner have challenged the selection of the private respondent, that is writ petition year 2010. Hence the court appreciated the non-preparation of Department of the Industry and Commerce not filing an affidavit in opposition where the selection process is under challenge. Therefore, this court direct the personal appearance of the Commissioner and Secretary of the Government of Assam Department of Industry and present in the course of the hearing. It will be open to the Industry Department to file any response to prior to the next day fixed. But this is not exempt that the personal appearance of the Commissioner and Secretary of the Government of Assam. Accordingly, this court is inclined to admit this petition for a hearing by issuing a rule returnable for within required so and so. Next date on 3/35/2019, Mr. Meenakshi Sundaram, Commissioner and Secretary of the Government of Assam Department of Industry is present, produced the order dated so and so. It is submitted that an affidavit in opposition has been filed in the matter. Yes. Next date, madam, 26/9/2019. A Standing Council for the Industry and Commerce Department submit that he required 4 weeks time to foreground that the government have taken a decision to look into the grievance of the petitioner, which required coordination from other department like finance, etc. On 28/11/2019, as per the court order dated 29/2019, A. Kolita Learned Standing Council was required to appear in the court about the decision taken by the government to look into the grievance of the petitioner. However, he is absent. Next, on 6/1/2020, SC Industry and Commerce Department submitted that the address is issued and draft cabinet resolution has already been prepared and same has been placed before the cabinet for approval. And the subject to the approval of this cabinet, not only the petitioner grievances will be redressed, but the ad hoc appointed will also be get the benefit of the regulation. Learned Counsel for the petitioner submit that except for the petitioner whose petitioner position was above most of the other candidates of the select list, the rest has been given the benefit of appointment, and his client is only left out. That for the appointment of the petitioner as per the position of the select list, no cabinet approval is necessary, and that on the principle first go last come, and on that strength of the being selected, the appointment should be have been afforded to him, which has not been done, causing miscarriage, immense prejudice to him. The court has reluctantly given 2 weeks time to Standing Council to update instruction. On 28/1/2020, subject to the above order dated so and so, which the court has reluctantly given 2 weeks time to get the update instruction in as the Standing Council has renew his pair, submitting within a month time process would be finalized. However, it is also directed that the meantime the department will also explore the option accommodating the petitioner even at the temporary basis pursuant to his position in the select list. So, my lord, your lordship kindly see no affidavit, nothing, no instruction has been done in that statement. In spite of this order, my lord.
So we have filed.
Affidavit filed one. Thereafter, no affidavit has been filed till today, man. So that is the position, man.
All right. Anything else?
That's all, man. Because I cannot. That was the experience because of that, my lord. Last 5 years, my lord, cases.
Lordship has rightly pointed out a couple of things.
I wish these things were pointed out in 2006. It would have saved so many persons of so much of agony.
The Lordship, as far as
Matters which should have been discussed and
Yes.
deliberated upon 15 years back.
Lordship.
It has been prolonged till today.
So,
And,
Lord-
it's
so
very
Lordship,
difficult to fathom.
I do not dispute one thing, Lordship, that is his name appeared in the select list. And I do not dispute another thing also, that couple of 6 candidates below in the bill, who were below, ranked below in the select list, they have been appointed. That is not disputed at all. Now, thing is that Lordship, only thing, like 2 things, Lordship, I would like to point out. First thing is the Lordship has rightly pointed out, the petition he has filed from the very beginning, the first round of litigation and the second round of litigation, that was filed on the premise that the whole selection process is illegal. The selection list is itself is illegal. That was of the premise on the basis of which the petitions have been filed. Now, first round of litigation, Lordship, I'll just point out one thing from the first round of litigation, that my learned senior has been arguing that he was not aware of anything till 2009, when he filed the RTI application. Now, Lordship, the first round of litigation, Lordship, let us see, Lordship, what was his prayer and what was his pleadings in the writ petition, Lordship. So for that, Lordship may kindly come to page.
Mr. Kalita, I think these things have already been discussed.
No.
First, writ petition, the pleadings were nothing to do with appointment.
No, Lordship, what my arguments will be basically because Lordship, because as far as like
You can argue on whatever you want, but
Lordship.
also address the court.
Lordship,
Why the court should not take limited cognizance of the fact that for whatever reason, persons below him were appointed. And therefore, why some compensation should not be directed?
my
Monetary
first
compensation.
No,
being
first-
paid by the department.
first line of argument, Lordship, what I would like to argue is that like delay. That there was a huge delay in filing in this petition, where he was aware of certain things, illegalities happened. Several writ petitions were filed, he was aware of this, then he came to the court after 15 years. So that I would like to point out, Lordship, what was his first round of litigation? Because there is a point of res judicata also, constructive res judicata, whether constructive res judicata will be applicable to this case. Or not. That Lordship has to kindly address to examine.
That your pleaded stand.
Affidavit, Lordship, we have filed an affidavit, Lordship.
If it is not pleaded, don't
No,
argue.
no, Lordship, I'll just point out.
The constructive res judicata has nothing to do here because he's already said at that stage when he filed the 2006 litigation, he was not aware what has
No,
happened.
that is what Lordship, I want.
All right, he ought to have been vigilant.
No, Lordship, I just wanted to point out what was his first round of litigation, what was his pleading in the writ petition. It is recorded in the order. So Lordship may kindly see this.
Recorded in which order?
The page 84, Lordship, may kindly have it. Dated, this order was judgment and order dated 28/4/2009. Paragraph 2, your Lordship, page 85. May I read out, your Lordship?
Yes.
Paragraph 2. The petitioner's case in brief is that wide advertisement published on so and so in 1993. Applications were invited for filling up some temporary post of extension officers in the Directorate of Industries, Government of Assam. But even before publication of the select list, appointment orders were issued to 28 candidates on 30/12/1994 and to 57 candidates on 23/1995. In pursuance to the earlier advertisement, the petitioner also applied for the posts and the name of the petitioner appeared in the select list, which was published on 22/3/1995. Subsequently, appointment letters were issued to some of the candidates in a phased manner, and accordingly 17 candidates joined the services again the said posts. Challenging the said process of selection, writ petitions being civil rule number 128 of 96, 398 and 96 and so were preferred by the sum of the candidates, and wide judgment and order passed on 1/9/1997 on the basis of the inquiry report submitted by the Secretary to the Government of Assam, Department of Industries. It was held that the entire selection process suffered from gross irregularities and illegalities, and as such selection was bad. Accordingly, the select list was cancelled, directing the authority concerned to issue fresh advertisement. It was also provided that those persons who were working appointed in the department on the basis of illegal selection should be given notice, and the necessary action should be taken against them if it was found that they were appointed without being properly and duly selected. Being aggrieved by the said judgment and order, some selected candidates preferred appeal before the division bench, and division bench while order it so and so, while upholding the impugned judgment and order, modified the same to the extent that in the case of appellants submitted by their reply to show cause notice, the authority concerned should consider the reply without being prejudiced by the observation made by the learned single judge affecting their cases. Accordingly, the respondent number 2 made fresh advertisement on 26/10/2002 for filling up of said posts. In response to the said advertisement, the petitioner has also applied for the said posts. According to the petitioner, even after receiving the applications in response to the advertisement that so and so, the official respondent did not take any action for selection and appointment of the candidates. These were known to him. All these facts about the litigations, division bench order, everything was known to him, Lordship. But he did not take any steps to come to the court at that point of time. Now see the prayer in that petition, Your Lordship. Being aggrieved by the inaction on the part of the official respondents in respect to the selection and appointment, the petitioner has come up with the writ application under Article 226 of the Constitution of India, seeking directions relief as follows: call for the records of the cases relating to the services of the extension officers serving under the Directorate of Industries, or who have sent on deputation on to other departments whose appointments have been quashed by the Honorable Court and are still continuing in the services, and or institute an inquiry by an independent investigating agency to fix responsibility on the persons who have appointed and allowed the illegal appointees to continue in their services till date as extension officers under a Director of Industries and Industries in spite of their appointments being declared illegal by the Honorable Court. Issue a writ of mandamus directing the respondents to disclose as to what steps have been undertaken to fill up the vacant posts of the extension officers under the Directorate of Industries pursuant to the advertisement published on so and so, and pass such other order and orders. So Lordship, he was very much aware of all the happenings, and he was sitting on the fence. He has not approached the court. Now the prayers he has made here, there was no prayer of his appointment at all. So once he was aware of all these facts, that his name was there in the select list, he was aware, then why he has not come before the court at the very first round of litigation, stating that he should be appointed and other appointments should be set aside? He hasn't done it. So that's why, Lordship, in the second round of litigation, when he has come, he cannot come with a new prayer saying that like, I should be appointed. And in that matter, Lordship, what I'm my humble submission is that constructive res judicata is applicable, because he was aware of all these things, but he did not pray for that. He has come in the second round of litigation after 15 years asking for appointment, but he was aware of all these things, Lordship. So Lordship, in that aspect, Lordship, Lordship is aware of this judgment, but still I'll place before your Lordship the State of EP versus Nawab Hussein's case here, Lordship. May I place it for the next 1 minute? 1977 2 SCC 806.
So which is the order by means of which the chief secretary was asked to conduct an inquiry?
That was in that single judges.
Do you have a copy of that order? Can you? That order and the division bench orders setting aside. Can you
Division
give me
bench and orders-
particulars of those two orders?
Yes, no, so I'm having it. I'll just tell you about it. It
Yes.
It's not a very clean coffee, Lord Siglet.
Can you take it out from the system to this? And the learned single judge's order 17/3/2004.
That I have given also.
No, by which order?
That direction was given in that order, stating that like inquiry should be made and the disposal of that petition is also there with me.
Yes. And where is the division bench order
Division-
demanding it better?
Division bench is also.
That order is in this proceeding only. Just drag it out. You don't have a copy of this, Mr. Kalita? His order? Do you have an extra copy?
Yeah, I
for-
have extra copy, Lord, so I'm just trying to find out. It should be with me in my file. Lordship may keep it, Lordship may keep it. I should be having it. Lordship, I have it. No, it will be elected, it will be elected. Then Lordship, this order is regarding the disposing of the writ petition, saying what has been after the submission of Chief Secretary's report. P1/2022. From the lack of
So, this order shows the petitioner has agreed with the chief secretary's report.
report, yes,
That
that's
the whole process is.
we
illegal.
agreed to that later on when other people went to the division bench, then he came back with this plea. His basic case was, Lordship, initially was that like there was illegal appointments, this should go, and 2002 advertisement, phrase advertisements should happen, and so that he can apply into that. In fact, he has given up that 1993 selection. Then 2000, he admittedly he has stated that like, he wanted
What
to-
has happened to the 2002 advertisement?
that has been cancelled later on, Lordship. Like in 2007, it has been cancelled.
It has been cancelled. Any notification showing it has been cancelled?
Notification, Lordship. Notification, Lordship, I don't have it as of now, but that has been cancelled. I've been instructed that has been cancelled. And that so Lordship, in view of this matter, Lordship, what my submission, very limited submissions I would like to make. First thing is the like, delay and laches is there. So that for that, Lordship, like I would like to place one case, and for this rest constructive res judicata. So Nawab Hussain's case, Lordship, That Lordship, if your Lordship, I will just place before your Lordship.
Yes.
I'll
which
directly
paragraph?
go to the that relevant paragraph, paragraph 8, your Lordship. It is not in controversy before us that the respondent did not raise the plea in the writ petition which had been filed in the High Court, that by virtue of clause 1 of Article 311 of the Constitution, he could not be dismissed by the Deputy Inspector General of Police as he had been appointed by the Inspector General of Police. It is also not in controversy that was an important plea which was within the knowledge of the respondent and could well have been taken in the writ petition. But he contented himself by raising the other pleas that he was not afforded a reasonable opportunity to meet the case against him in the departmental inquiry, and that the action taken against him was mala fide. It was therefore not permissible for him to challenge his dismissal in the subsequent suit on other ground that he had been dismissed by an authority subordinate to that by which he was appointed. That was clearly barred by the principle of constructive res judicata, and the High Court erred in taking a contrary view.
Yes.
So this is the known case, Lordship, the Namba Hussain's case. And as far as Lordship, as I pointed out, Lordship, that delay, Lordship, that a huge delay, then third party rights have been created, other people have been already appointed, and after that he has come. So for that also, he's kind of a, like that Lordship I have already read out, that he was aware of all these litigations happening in the court, but still he was sitting at the fence. He was not coming before this court, but he was now after such a long period, he is trying to take a chance. So on that, Lordship, like that delay and laches, Lordship, the principle of delay is well known. I'll just read out one paragraph of this citation, your Lordship. This is Lordship 2009 to SSC 479. Paragraph 17, I'll just read out your Lordship.
Yes.
Paragraph 17, your Lordship. It is also well settled principle of law that delay defeats equity. The government order was issued on 15/1/2002. The appellants did not file any writ application questioning the legality and validity thereof. Only after a writ petitions filed by the others were allowed and the state of Kerala preferred an appeal against they implemented themselves as a party respondents. It is now a trite law that where the writ petitioner approaches the honorable court after a long delay, reliefs prayed for may be denied to them on the ground of delay and laches, irrespective of the fact that they are similarly situated to other candidates who obtain the benefit of the judgment. It is thus not possible for us to issue any direction to the state of Kerala or the commission to appoint the appellants at this stage. In NMDC versus Pansing, this court held there is another aspect of the matter which cannot be lost sight of. The respondents herein filed the writ petition after 17 years. They did not agitate their grievances for a long time. They, as noticed herein, did not claim parity with the 17 workmen at the earliest possible opportunity. They did not implicate themselves as parties even in the reference made by the state before the industrial tribunal. It is not their case that after 1982, those employees who were employed or who were recruited after the cutoff date have been granted the said scale of pay. After such a long time, therefore, writ petitions could not have been entertained even if they are similarly situated. It is tried that discretionary jurisdiction may not be exercised in favor of those who approach the court after a long time. Delay and laches are relevant factors for exercise of equitable jurisdiction. So, Lordship, in this case also, Lordship, the knowledge part, Lordship, he had the knowledge.
All right.
He had the knowledge,
Yes.
only he approached his court. pretty late, and in view of that lordship, and as far as like the constructive res judicata principle also, he cannot raise this plea in a subsequent petition. So these two are my limited. So this petition may be dismissed.
There is a judgment of the division bench, Justice Sapre, where these orders were set aside, then this matter has been remanded back. So if you can get a print out to Anjan Kolita will. Yes, who is appearing for the private respondents? You are for whom, Mr. Prakash?
6 to 10. And so far as my lord, my crimes are concerned, my lord, out of 6, only 2 are in service. My lord, rest are, my lord, either expired or retired from service. I'm just giving you, my lord. Respondent numbers, private respondent 6 expired. Mukul Goswami is still in service. Respondent 7. Dijen Chakraborty retired. Devan Kolita is in service. And he is going to be retired in the, my lord, this year. And
Who expired?
my lord, respondent number 6,
Hmm,
Prakash Goswami.
7.
7 still in service. 8 retired. 9 in service. And 10, my lord, retired. And respondent number, my lord, 9 is going to be retired shortly. My lord, almost all the, my lord, submission was, my lord, point where, my lord, addressed by the, my lord, government advocate. I will add 2 things, my lord.
So they are all below the petitioner. and the
Yes,
select-
it is admitted fact, my lord. I cannot, my lord, just dispute it. Lordship, kindly let me refer to para 11 of the writ petition. On the basis of that, my lord, can I say that, my lord, writ petitioner has got the fullest knowledge. And in spite of having the knowledge, he did not seek any relief. What he is now seeking in the present writ petition. I'm just reading para 11. Lordship, kindly have a look, my lord, para page 12.
Yes.
In the first week of September 2006, this, my lord, is very relevant because earlier the petition was filed on 22nd of September. And he said, my lord, he had the knowledge in the first week of September. The petitioner, in his utter shock and astonishment, has come to know that all the undermentioned person, Lordship, kindly look at the undermentioned person means Prakash Goswami, respondent number 6. Mukul Goswami is one of the party in the present petition, Dijen Goswami and Karim Kazi. These are the person who were appointed in spite of being below him in the select list. And he had the knowledge. And to his utter shock and astonishment, he has come to know that all the undermentioned person who were earlier party to the writ petition before the honorable court are still working, my lord. Therefore, my lord, once he had the knowledge, what has prevented him to speak to him in 2006? And 2006, my lord, there are 4 different prayers, except, my lord, the prayer number 4 of the present writ petition, which was not made in the earlier writ petition. In the present writ petition, he sought for a writ of mandamus, directing the responding authorities to appoint him. Therefore, that prayer was, my lord, he could have made in the earlier writ petition. Therefore, basically, my lord, it is a barred by res judicata. And I have taken that plea, my lord, in my affidavit in opposition at page 30, my lord. That plea was taken by me in, my lord, para page 30, or you will find. On the other hand, my lord, so far as the, my lord, continuation in service is concerned, and division bench has, my lord, taken into consideration, and, my lord, applying the ratio of Roshni Devi, since they were allowing to continue for such a long period, therefore it is not equitable and wise to unsettle the settled position. Therefore, court is not inclined to interfere. And same view was, my lord, expressed, and that view was accepted by division bench by applying the equity. Therefore, it is a settled
Which
position of-
division bench? Division bench in which case?
My lord, in that case, my lord, I'm showing your lordship. Amitabh Roy and C.R. De, my lord.
CR they.
Yes. Sorry, C.R. Sharma. C.R. Sharma. Extra copy. Okay, Sharma, yes. Right. ये तुम तो ये बिल्कुल तो ये तुम लोग किसको बात है वो रिवीजन चुके लोग हाँ द्वितीयটা জ্ঞান হবে না বিপদ সমাজে কেস করব বিপদ আছে আমি একই হলো না তোমার কেস নেই আপনার রেফারেন্স দেন না আচ্ছা তো ইয়া ইন্টার ব্রাঞ্চ যে শোনো বিপ্রশনা জার্নালটা সেকেন্ড করলো না That was the judgment given by my lord, delivered by Honorable Justice Amitabh Roy and Justice my lord C.R. Sharma. My lord, against the, which was preferred against the judgment and order dated 16/10/2000. My lord, first in WPC number 3996 of 2001.
All right. I have noted that. What
Yes.
else? What else, Mr.
And therefore, my lord, so far as me is concerned, my lord, I of course cannot improve the case that, my lord, we are below down the petitioner. But after the lapse of time, my lord, law is well settled that once, my lord, huge time expired, the court is not going to, it is not wise on the part of the court to interfere and unsettle the, my lord, settled position. That much is the, my lord, only submission, because otherwise, my lord, if I do survive, then, my lord, he might have some right to be considered. But if my appointment is cancelled because of the fact that entire selection list is illegal, then he does not have any right. Because Lashia rightly pointed out, one cannot enforce negative equality. Some wrong was done, and you are approaching the court, my lord, convincing the court to do wrong. Therefore, court cannot perpetrate any wrong. This is my
Right.
submission, my lord.
Yes.
And my lord, on the other hand, my lord, some person, my lord, all persons who were appointed, by that time, they got promotion. And some person were given the pension. So in that situation, whether my lord Lordship will, my lord, interfere and my lord take into consideration the entire selection process was declared as
All right.
not valid.
All right. Yes.
This is my submission.
Yes, Mr. Nath. There's no need to repeat whatever. has been argued.
Just repeat. I'll not repeat, my lord, because lordship is
Your
say,
fault, your fault.
I am for my lord, respond number 11 to 19, except 12. Except 13, except 13. Out of that presently, my lord,
And who's for 13?
13 is, I think he has retired also. And he expired also, I think, something like this, my lord. Who's not so retired, my lord, I don't know exactly. But my client, my lord, the respond number 11 retired, 12 expired, my lord, 14, 15 and 19 are serving now, my lord. And they will be returning very soon, I think, in the 2-3 months.
11 retired.
11 retired, my lord. 12 expired. 12 expired. 14 is serving, my lord. 15 is serving. 16 retired. 17 retired, 18 retired, 19 serving. 3 of them are serving.
17 is serving,
3, yes.
17 is serving.
17, no.
Then
Only, my lord, 14, 15 and 19 serving.
yes, what do you have to submit?
My lord, I've got a precise small submission I have got, because when my learned friend, if your lordship come to prayer part, my lord, page 22, lordship will see, my lord. Para 1, 2, 3, Roman, he is not pressing virtually. That's what he's saying, my lord. He wants appointment, my lord. That is in paragraph 4, Roman 4. That's what. Now, he wants appointment because according to him, respect number 6 to 10 were below him. That's why he said he should be appointed, my lord. That's what. Even your lordship, one of the order also, I find it is recorded, my lord. And also in paragraph 14, page 16, my lord, he has made this statement. Paragraph 14, page 16.
Hmm.
So regarding this prayer, my lord, 4,
And why your clients have been made parties?
As per direction of the division bench.
because
They went to division bench.
yes, I myself, I
Because
appeared
they are
as my
acted
lord.
by the chief secretary's order.
Order. Yes, we are not made a parties.
You are not seeking any relief against
Like
them.
this.
That's what, my lord.
That's
Yes,
because
my
they are, my lord.
Even I'll be happy, my lord. Otherwise, law is lordship has already observed, my lord. Otherwise, I could be a happy person, my lord, because lordship is seen fighting for all these years, but because of the time faction, my lord, really all these things are there. That I will not make any comment on that, my lord. That's between lordships and the respondent authorities, my lord. So virtually, my lord, since he's confining his argument on paragraph on serial number 4 of the prayer, my lord. So I don't have anything to say, my lord, virtually, my lord.
So you have nothing to say.
Nothing to
You
say.
can
almost, my lord.
just-
Yes, obliged, my lord.
What I'm giving reply to that, my lord, Kolitas. What, my lord, what stated by my learned friend, absolutely out of pleadings, my lord. What they have stated in the affidavit and what he stated is totally, my lord. Your lordship kindly see in their affidavit, no delay, no, my lord, res judicata, date points are not being taken, my lord. Now, my lord, your lordship, that in fact, in that, my lord, one submission I have to make, my lord. He said that, my lord, it is cancelled. This affidavit was filed in 2011. The your lordship kindly see para 10, they have stated, as regard the statement in paragraph 9 of the 7 of the petition, the department beg to state the process of filling up the post of which was advertised in the 2002 is still pending. Now he says that is, my lord, that is dismissed, my lord, that is already cancelled, my lord. But that is, there is no affidavit, nothing has been filed, my lord. And my lord, in that affidavit, your lordship kindly see, not a single line regarding delay nor regarding, my lord, that has been argued, my lord. So what he argued, my lord, out of pleadings. Another thing, my lord, I am submitting, my lord. I made a RTI application, and that is the page 89, your lordship kindly see. Page 89, that was the RTI application I have made on 22nd July 2009. In that RTI replied, my lord, they have given this appointment, that the appointment of those 6, my lord, who I made party. Because in my second writ petition, in earlier writ petition, I have not, my lord, questioning that, my lord. I came to know that these 6 persons, who's my learned friend representing, my lord, I came to know these are the person appointed after getting the RTI reply. There is a RTI reply, my lord. Your lordship kindly see, and that RTI reply, they have annexed that document. Then, my lord, I filed this writ petition annexing, but made them party, my lord. So that is my in second writ petition, my lord. Because I am submitting, I write because they are below me, they were appointed. That's why I'm submitting, my lord. And that I do not know, my lord, until and unless I have given reply to my RTI application, my lord. So in that way, my lord, there is no res
But
judicata.
what they're saying is, even then, there is a period of 4 years delay.
That RTI apply was, my lord, given in 2009,
No, he's saying at para 11, you have stated
my
that
lord.
in 2006, you came to know. That
No,
these
no, no,
four
2006, my lord, no. Your lordship kindly see, 2006, my lord, 2006, my lord.
Please
my-
come to para 11 of your petition.
No, that was, I am not sure, my lord, and I made a statement. That's why I'm not made party. I came to know, my lord. Yes. So that's why, my lord, I made the RTI application, my lord, after this judgment, my lord.
No, Mr. Mahanta.
My lord.
See. These respondents 6 to 10 represented by Mr. Prakash.
My lord,
He is admitted that they were below your client in the merit list.
my lord.
Correct. So you have stated in your writ petition, which is a statement that in September
Fair.
2006, in
My-
para 11,
my
para
lord.
11, September 2006, he came to know that those persons were illegally continuing, meaning thereby that despite being below your client, they were illegally continuing. You have named them these persons. They are the private respondents. So from September 2006 to 2010, where is the explanation of the delay?
No, that time, my lord, the case is pending, my lord. Your lordship kindly,
Which case is pending?
2006, my lord, because my earlier writ petition, my lord, 2006. My earlier writ petition was 2006, my lord.
Correct. The earlier writ petition, you don't want appointment.
My lord,
You didn't want appointment. You
My-
wanted an inquiry,
My lord.
information.
my lord.
So
No,
you got the information in September 2006. That is your own statement, Mr. Mahanta. That is the statement of your own client. It is absolutely bold and in clear terms. That once you came to know that these persons below your client were illegally appointed and continuing in service, you did not approach the court till 2010. What is the reason for this delay?
And I have checked that my earlier application was filed on 21st September 2006. I checked up, my lord, that I think the earlier application was filed on 21st September 2006.
P6, my lord, P6.
So, Mr. Mahanta, I think there are a few things you need to examine, perhaps. This writ petition was filed in 2014 in amended form,
My lord.
correct?
No,
So
amended,
what was the amendment made?
no amendment only, that's adding the party only.
That's all.
In pursuance to the order of the division bench,
Hmm.
so you go and make them party. There's a direction that you make them party.
Okay.
We made them party by amending, not pleadings, only on that.
Only on- But in any case, this writ petition was originally filed in 2010,
10,
at least middle of 2010.
my lord.
So apparently there is a delay of 4 years.
That's my lord. Yes, I have seen.
What do you have to say on that?
Oh, my
There is
lord.
nothing, and these are facts which are by the own showing of the petitioner. 4 years he did nothing. So today,
No,
if
my
you are
lord,
to be
actually-
accommodated, somebody has to lose his job. Somebody has to
In
lose his job.
2006, my lord, we filed earlier writ petition, my lord.
Hmm.
Earlier writ petition, my lord, we seeking some information, my lord. We came to know, but that I admitted, my lord, yes, if I made a statement that, my lord, I have not done for it, my lord. Then, my lord, concrete evidence I am getting after, my lord, your lordship kindly my RTI application, my lord. In RTI application, my lord, when I filed in 2009, in pursuant to the judgment of the honorable court, my lord.
Hmm.
Then only, my lord, they have given the appointment letter of those.
But
my lord.
you knew about it in as per para 11 of
Yes,
your writ petition.
That's true, my lord.
Then.
But I did not get any that concrete evidence, my lord, regarding their appointment and all.
Evidence is another thing.
But even then, my lord, when there is a My lord, your lordship kindly.
Lordship, I'll just point out.
No, my lord, regarding
For
his, my
lordship.
lord, what is the, he started, my lord, there is not in affidavit.
No, no, Lordship, that's what,
Absolute nothing.
that's what I'm, such a bold statement has been made. So I need to point out. So Lordship, I have filed an affidavit in the month of January two thousand
So
thirteen.
you sort out in 5 minutes, we'll be back.
So there. Page 190, Lordship will find probably. In Lordship's record, page
190 or 119?
190. There is an affidavit filed by the state. No, in the affidavit.
Yes, it is there.
For
Yes.
filing.
So out there, Lordship, only regarding that pleadings, Lordship, that about res judicata and delay. So out there, Lordship, paragraph 17.
Yes.
Paragraph 17, Lordship, may I read out that Lordship, that the petitioner, Sri Tilaknath, had again filed writ petition number 4916 of 2006. An honorable court was pleased to dispose of on so and so with the note, a person cannot be allowed to make wrongful gain out of an illegal state of things. As such, the petitioner has filed this second writ petition on the same grounds as stated in the earlier petition, writ petition. So that is the res judicata, Lordship, the point. And secondly, Lordship, paragraph 18, the petitioner is not entitled to any relief as sought for in the writ petition on the ground of delay in approaching the honorable court after 15 years, and the same is liable to be dismissed, and there is no such explanation of delay in the present case.
Any rejoinder filed by the petitioner?
No, they haven't.
I have not,
They
today I have
haven't
seen,
filed.
my lord, today I have seen.
That is
my
there on the
lord.
record.
The earlier affidavit. And
2013
here
we have
also, my
filed.
lord, I have seen just now, my lord. Here also regarding advertisement, my lord, they are still pending, they have stated.
The advertisement was cancelled in 2017.
All right,
That's what
so-
instruction.
That's all. Anything else, Mr.?
That's
That's
all.
all, my lord.
All right. Heard Mr. T.J. Mohanty, Learned Senior Counsel, assisted by Mr. W.R. Medhi, Learned Counsel appearing for the writ petitioner. I have also heard Mr. A. Kalita, Learned Standing Counsel, Industries and Commerce Department, Assam, appearing for the official respond numbers 1 to 5. Mr. A.K. Prakash, the Learned Counsel, has appeared for respond numbers 6 to 10, whereas Mr. M. Nath, Learned Senior Counsel, assisted by Mr. D.P. Bora, has appeared for respond numbers 11 to 19, except respond number 13. First, arguments concluded, judgment reserved.
Lordship, Lordship, on that synopsis, Lordship, would like to have, I corrected it. Lordship.
These orders and the synopsis, you just make it into a folder. Respond number 6 to 10.
For hearing item
Yep, yep.
14, top of the list.
Yeah, please. Petra, maybe kindly pass over for the time being. This is.
Item 14, one.
Oh, sorry, I'm sorry.
Yes, who is appearing? All right, pass over.
Item 14.
Next matter, next matter. We are calling the next. Mr. Agarwal's matter you call. Pass over.
Item 8, order stated.
Pass over for the time being.
For admission, item 9.
Yes,
The last occasion, but we were not basically on the subject that the notification dated 22nd of November 2016. By that notification, my lord, it says that we have filed an affidavit, my lord, in this case.
when,
My lord, yesterday we have filed.
yesterday you filed.
My lord, we got some documents the central government, where they say, that those, are explained to that, not anything else. My lord, your lordship will kindly see, their first plea was that. they-
No, no, that's all right, but if you filed it yesterday, then who's the respondent? Copies have been
Kalita
signed.
is here.
Huh?
Mr. Anjan Kalita is
He
here.
is left.
For 5 years.
Mr. Kalita, you are appearing in this case. It seems some affidavit has been filed yesterday.
Yes, lordship, resender has been filed, but out there, lordship, what they have done is that they have given a list of claimants who have, as per them, they have been given their claims have been allowed in spite of their date of commercial production was after the withdrawal of the scheme. Because we are pleading that like the scheme is already withdrawn, and since they haven't done the commercial production during the validity of the scheme, so they cannot be allowed. So that was one of the pleas we have taken. Now what they are coming up with, a list of some claims where they are saying that like these people have also gone for commercial production after the withdrawal of the scheme, but they have been allowed, so we should be also allowed because of discrimination in
So
that.
this is a fact brought for.
This
the
is a
first
fact
time.
brought in. So that's why, lordship, I would like to have some instructions in that because I do not know anything. Yesterday only it has been given to me in the afternoon.
You cannot let them not verify.
How much time you want?
1 week's time, lordship.
No, right.
1 week is not possible. We'll do it for 2 weeks then.
2 weeks,
We'll
lordship. 2 weeks
adjourn it
time.
for 2 weeks.
Then if required, then I will file a surgeon there also if required.
My lord, I have.
Only on factual part, nothing else.
I'm sorry. In this case, my lord, I have two arguments. My lord, first argument is that the 22nd of November 2016, it says that my lord, it has been withdrawn, but my lord, exception has been made that scheme will continue. So for the person concerned who have been already registered prior to that. Now, my lord, they have not said anywhere that my lord, regarding commercial production should have been started within that. And the other day, my lord has pointed out, I have also seen, my lord, clause 6. Validity period of this scheme. Validity period of this scheme, if your lordship looks into the clause 4, its validity is for 5 years. So, my lord,
Then we'll admit it and post it for hearing in first week of September. In the meantime, you can file a
I'll
clarificatory
clarify this factual.
affidavit. Mr. Agarwal? Because
my lord,
you filed
my
a
lord, my
pleading.
lord has already had my lord, the matter is 2 days already.
Yes,
one day.
but after that you can't file the pleading then.
No, that's so.
You have to choose one of the two. You can't file a pleading after the hearing has commenced.
No, that's true, my lord, your lordship rightly on the other day said that, my lord, I may not accept. Lordship said that your lordship may not.
Oh, you see, the problem is, if hearing has commenced, then without leave of the court.
My
pleading
lord,
cannot be
that's
filed.
true, my lord, I sought the leave, my lord. On the last occasion, orally, I sought the leave. Let it be, my lord.
No, it's all right. We'll accept the pleading.
Yes.
But then
So-
he has to give.
Yes, he has to verify it, my lord, definitely. The copy has been given to Central Government Council also. my lord. And the documents which we have annexed are, my lord, released to the central government because they have, my lord, President has sanctioned the, my lord, for disbursement of subsidy of several persons whose industrial units were, my lord, registered either 1 day or 2 day prior or earlier also, but they started commercial production after 2016. There are at least, my lord, 20-25 industries are there.
Mr. K. Agarwal, Learned Senior Counsel, executed by Mr. S. Bharani, Learned Counsel is present on behalf of the writ petitioner. Mr. A. Kalita, Learned Standing Counsel, Industries and Commerce Department, Assam submits that affidavit in reply has been filed by the petitioner only yesterday by bringing on record certain new facts which would require him to obtain instruction and if necessary file a clarificatory affidavit. On such ground, Mr. Kalita has prayed for 2 weeks' time. Mr. Kalita has prayed for listing this matter again after 2 weeks. Similar is the stand of Mr. K. Gogoi, Learned CPC Assam and Mr. R.K. Bhatra, Learned Counsel appearing for the respond number 9. Respond number 9. Although this matter was heard in part on the last occasion, yet since the petitioner has brought in pleadings after the matter was taken up for final disposal at the stage of admission hearing, this court is of the opinion that time as prayed for by the learned departmental council should be allowed. More particularly since some new factual aspects have been brought on record by the petitioner. As such, admit this writ petition. Since the parties are already represented, no formal notice is required to be brought on record. The parties are at liberty to exchange pleadings as per the requisite norms. Register to list this matter for final hearing in the second week of September 2020.
Tomorrow we fix a date,
You decide whatever date.
the 11th. And hearing day will be 12th or 11th.
14th of September 2023.
Obligers.
Item 14.
No, just a minute.
My lord, I apologize. I'm sorry. Just when I missed the first call, I went to call my junior.
All right, all right.
He was waiting outside.
There are some admission and orders matters. We'll quickly finish them and then
Yes,
continue with it. Please
Uh,
wait for a little while.
I will try to be very brief as the only point of law and some rules and regulation. I think. May I start, my lord?
No, just for 10 minutes, we'll finish
No.
up some
Okay, okay, I am waiting.
admission matters.
Yes, yes.
Item 10.
Your Lordship, a writ appeal has been filed against a similar writ petition, and the writ appeal has been listed today, Your Lordship, in court number 1. Let that be decided first before this matter can be taken up, Your Lordship.
Your Lordship, both the arguing councils are on legs before court number 1.
Writ appeal against what, which order?
Your Lordship, in another writ petition whereby order under section 26(1) has been challenged, Your Lordship, and the writ appeal has been listed in court number 1.
It is submitted at the bar by learned counsel for both the sides that,
Lordship, that is pertaining to a different matter also.
sorry,
Different company, but the order under challenge is similar.
Your Lordship, although the order number is same, but then the matters are different.
so what is your submission? Writ
Your-
appeal is being heard.
Lordship, let the matter be passed over for some time, post.
No, sorry. It is submitted at the bar that a writ appeal arising out of a similar matter and involving the same legal issue
Yes, Your
is
Lordship.
being presently heard by before the division bench, wherein the learned arguing counsel for both the sides are engaged. As such, awaiting further order in the writ appeal being WA number
Your Lordship, 281 of 2023.
281 of 2023. This matter be adjourned for another 2 weeks.
Yes, Lord.
First up, taking note of the prayer made at the bar, this writ petition stands adjourned for.
Your Lordship, there is an interim order made that
Interim order passed earlier to continue.
oblige, Your Lordship.
10 and 11.
12.
My lord, pursuant to your lordship's order, a copy of the report was given to us.
Yes.
Copy of the report was given to us. My lord, it says, my lord, for an proper demarcation, they would like the assistance of this authority called Director of Land Records. That is in substance, that is what they are asking for, my lord. And my lord, from the state government's perspective or revenue department perspective or from the circle officer's perspective, that it is that in tribal belt and block something has been done illegally, that is not the case. A case which my learned friend Mr. Chaudhary would like to project. Therefore, my humble submission is, my lord, let us start our operation, let them do the exercise. In the event, if it turns out that our land falls in, my lord, a non-cadastral area, then my lord, law will take its own course. But for the present, why should we stall the product? As such, my lord, we are prejudiced from 28th of April, my lord, it is already under, my lord, indirectly, my lord, because it's an integrated process. Therefore, the place where the blockade has been set up, we can't operate the factory, my lord.
Is there any order of 28 April 2000?
No, there's no order. And most importantly, my lord, before taking all this steps, no notice, nothing was given to us. All of a sudden they came. So in fact, my lord, that is what is indicated in the earlier order of this honorable court also, my lord. That based on the, the report of the CEO, my lord, the court would like to take a call on the interim player. If a lordship will kindly come to order dated 27th of June 2023, my lord. The last but one para, be that as it may, the learned senior counsel for the petitioner has submitted that as the industry of the petitioner has been closed down, he may be permitted to resume the factory on any condition that may be imposed by the court, and on the strength of the undertaking of the petitioner that they would discontinue operation of cement factory as and when ordered. The respondents are put to notice as to why as a temporary measure and till further orders, petitioner shall not be permitted to operate the factory. So subject we undertake to avoid by any further orders the lordship may pass. And this process will take some time, my lord.
Where is the report? Is it on record?
My lord, it was given last on occasion. my lord.
Where is the report?
My copy of the Murta deta hai.
There was a seal.
Lordship handed over back to the. এখন পেয়ে দেয়া হয় এখানে। If your lordship would kindly come to the first subpara, as per direction of the order, alert staff of the circle office in presence of representative of Messrs. Purvanchal Cement carried out demarcation over the schedule of the land as desired by Purvanchal Cement Limited. The Purvanchal Cement Limited has possession over the plots of land covered by patta number 1, 4, 3, and 5. Dag number 2, 3, and 4, which are cadastral land at village Holtari. However, in case of rest of the plots of land which are covered by non-cadastral land, the actual demarcation could not be carried out as there is no surveyed or so-and-so map of the said scheduled land. As the office of the undersigned has no survey map for the land illegally occupied by so-and-so, hence demarcation as instructed from your end could not be carried out without the so-and-so map. Dag numbers cannot be ascertained in the field because they are not reflected therein. In this context, it is pertinent to mention here that for more accuracy over all the demarcation of the government land occupied by Purvanchal falling under non-cadastral village, the assistance from the office of the Director of Land Records, survey for joint survey is highly needed. So they say partly it is in cadastral village, partly.
So what is the allegation that you are occupying land falling in tribal belt?
No, that's not the allegation.
Then
They basically they would like to say, my lord, we are occupying land which is not, demarcated.
demarcated.
Indirectly government land. But we have pattas in respect of all the lands, my lord. We have got permission, we have got Jamabandi, everything, my lord. On the last occasion, I have given one chart, my lord.
No, but who has raised this objection? Respond number 5.
No, it is not nothing, no action has been taken at the instance of respondent number 5. At least, my lord, no, so we don't know, my lord, no show cause notice was given. All of a sudden on 28th of April, they came over and my lord sealed the premises. My lord, yesterday I checked up with one of my friend who happens to be a retired revenue secretary. He said in Guwahati, for example, in Fotasil, non-cadastral village, so many pattas have been issued, my lord. Yes, technically it's a correct concept that if it is village is not or area is not surveyed, how, who will identify which plot is or land falls in the which dag number or patta number. But there are instances, my lord, even in non-cadastral thing also, my lord, they have issued pattas. Just out of my curiosity to know, my lord, whether what is the actual position. He said technically it is correct that it normally can't be given, but there are instances where it is being done also.
So who are the petitioners? How many petitioners? Are
Petitioner
there?
is the 4 petitioners, my lord.
Who are there? How they are connected with each other?
There,
owner of the factory and the land, my lord.
No, I find that there are two different companies here.
Yes,
What is the connection?
we have all owners of the cement factory, my lord. We have explained.
What is the connection between Purvanchal Cement and Northeast Industrial Power Private Limited?
My lord, they're all director in the Purvanchal Cement, my lord.
But why composite writ petition has been filed? There are two different entities, two different cause of action.
No, because of the land, my lord. Because the factory is spread over land of which, my lord, all the petitioners are owners. It's not a composite plot of land. Had it been a case where all ownership of the land vests with one person or Purvanchal, then question of making them party would not arise. Because part of the
No,
land.
not making a party. I'm referring to the
No,
petitioners.
because, my lord, the land is owned by all of them, my lord.
That's right. So authorities, both are cement plants.
Yes, it's an integrated process, my lord.
You have understood what I'm saying.
Yes.
This writ petition is not maintainable.
No, my lord, it's not a question of misjoinder of cause of action. It's a question of being who are the owners of the land. They alone can come before lordship, my lord. My lord, supposing I own a factory and factory is over a premises, say 10 biga, of which are 5
Understood.
biga.
The reason I'll indicate. Why have they been joined? Why not two writ petitions by the two set of companies? Why it has been
So
joined?
since, my lord, ideally it could have been, my lord, in a 220.
Because you see, it will be difficult to give a mandamus. We can only ask them to verify.
Block land are different.
Verify because
No, my lord, the problem is, if a lordship would kindly have the chart which I've given. I've given one chart the other day, my lord. Petitioner number 1.
This is petitioner number 1 and 2 and 3. So that half is blocked here, half is blocked here.
no, Mr.
Now,
Chaudhary,
I am explaining, my lord.
I don't want to be technical, but there is a technical hurdle here.
No, I'm coming to
Because
that.
this report only relates to Purvanchal Cement.
Hmm.
So whatever order will be passed only will be confined to Purvanchal Cement, not the other petitioner. I'm making it very clear. Because this report has no reference to the petitioner number 3 here.
No, why I have made them parties, my lord, will kindly have a look at the schedule, my lord. Sorry, the chart which you have given the other day.
Yes.
This is schedule A is
Purvanchal.
Purvanchal. Schedule B is.
Whether lordship has got a copy of the chart, my lord, I can give one more copy. Yes. Schedule B to that one, and schedule B ownership but key correct.
Integrated person. Aru these links in maybe
My lord will kindly see schedule A land that belongs to Purvanchal, my lord.
Right.
60 bigas, 2 kotha, 3 lesa. Then schedule B belongs to the other entity, my lord. And the factories over this whole plot of land. Cement factory. And my lord, in addition to this, there is 20 biga, 4 kotha, 19 lesa, which is under lease. Of which, my lord, the CEO has not taken note of.
And blockage is half.
And my lord, the blockage is, if your lordship will kindly come to page number.
Yes.
1 second, my lord. Please come to my lord, page number 240. My lord will kindly come to page number 249, my lord. It's a photograph.
Yes.
On top, kindly see the photographs, my lord. Sarkari Bhumi, there is a Probek Nikhet, something like that, my lord. So these are schedule A and B, these are complete land, my lord. Now the blockade has been set up in between. So one from the schedule B land, we cannot go to schedule A. Some part, my lord.
কোনটা ব্লক হয়েছে
So this is how, my lord, the land is situated. Anyway, this is nobody's case, my lord, with all respect, my lord. The idea which was court impression which was given to the honorable court was that part of the land is a government land. Therefore, they have taken the steps of putting that, my lord, restriction. Now they themselves say, my lord, that it is to be, surveyed and only we can give a final call. So what is the justification of doing it? At least we are entitled to a notice. In case a notice would have been given to us, they have explained the position. And not an inch of land is, that the government land according to us, because we have got sale deed in respect of all the land, and the lands were duly mutated in our name. Jamabandis have also been given. And my lord, in such a scenario, this action was highly arbitrary, my lord. That is the reason we approached your lordships. Now, it's an integrated process. Lordship knows some, component will be left in a particular place, then it will be carried in the conveyor belt, then eventually, my lord, finished product will emerge. So therefore, our humble submission is, let us proceed with the operation, my lord. Let them complete within a time frame, 2 months or something, whatever time they take. Subject to what report comes, my lord, lordship will take a call. And we give an undertaking, will abide by any further order lordships may pass. Supposing, my lord, tomorrow a question comes, the land falls in tribal belt. It may come, my lord. Because let us take the point of view of my learned friend, Mr. N.B. Chaudhary. Then also, my lord, land revenue regulation is not helpless, my lord. There are situations where in the interest of economic development of the state, my lord, this is an industry which is directly employing 250. Indirect employment is above 500, my lord. It's paying revenue of 83 crore annually to the government, my lord. And what will happen to these people, my lord? Will wind up, will go away. So therefore, these aspects are also there. End of the day, my lord, we have come to do business. We haven't come to pick up any quarrel with the government. Ultimately, if we cannot settle the matter, of course, my lord, we'll have to wind up and go. So therefore, my humble submission is, my lord, the initial action was arbitrary. They should have given us a notice. Even you could have persuaded them, this action is not required because of these are the reasons. That opportunity was never given.
Circle officer has come and asked you.
All of a sudden, yes. Circle officer came and he put a seal in between, my lord. The actual picture is this, my lord. This is my submission, my lord. We'll abide by any order which your lordship will pass. And this was indicated in the 27/6/23 order also.
Whether the materials annexed to the writ petition as well as the environments made in the writ petition would go to show that they had purchased this part and parcels of land by various sale deeds. Beginning from the year 2003, they were continuing. They had purchased the land, my lord. Now, whether purchasing of tribal belt land and setting up an industry there is an issue altogether not within the domain of this writ petition. Now, my lord, what had happened, by passage of time, my lord, what I have been instructed by the circle officer. In fact, yesterday we had called the circle officer to the chamber, to our chamber, as well as, my lord, the additional director of land records to justify this report. Now, by passage of time, my lord, they have, my lord, expanded their, my lord, factory. And they have, my lord, transgressed into government land. Now, my lord, meaning thereby, by dint of this sale deed, they have purchased this plot of land. They have set up this industry. They are running. At no point of time it is their case that prior to the action taken by the circle officer, impugned hearing, any other such action were initiated by the revenue authorities. Why now? Because of the fact, my lord, that this plot of land which they own as per the sale deed and which have been mutated in their hand, by passage of time, my lord, they have, my lord, expanded. They have expanded to other areas. So that has been, my lord, brought down. That is the precise reason. So the whole factory has been stopped. It is their case, my lord. Because they are entitled to carry business within the parameters of law, my lord, in respect of the plot of land, which they are. That's right. So show me the document which mentions about this allegation against the petitioner. Where is the notice?
Notice, my lord, here we have not yet
So
filed
how
any.
can the circle officer act without a notice? Well, he has a power to orally go and do all these things.
My lord, here we have not filed affidavit of course right now, till now. My lord, we are awaiting the instructions. We have, my lord, communicated to the authorities. And yesterday, my lord, we had a meeting with the circle officer as well as, my lord, the additional director of land records, because this report, lordship will find. So the circle officer has prepared this report, my lord, it appears, my lord, all the things have not been, my lord, filed out here.
Maybe, but then he has
Yes.
submitted this report
No,
as per
he
court
has
order.
submitted this report. Now, my lord, we have advised the circle officer as well as, my lord, the officials of the director of land records, as well as, my lord, the survey training school Assam. My lord, that you have to go and make a proper identification of the land, demarcation of the land, and submit a consolidated report before this honorable court. That will ease out everything, my lord. Lordship will take a call on that.
Yes, but in the meantime, he wants to
Till then,
operate
yes.
the factory.
But till then, my lord, lordship will permit subject to, my lord, running their factory over the plot of land which they.
Oh,
they
oh,
are-
Mr. That cannot be done. You also don't know which land is their land and which.
No,
is-
my lord, it is there, my lord. Schedule A, Schedule B. It is there, lordship will
Yes,
pass
we
on.
confined to Schedule A.
Schedule A, Schedule B. It is
We
their
confined
case.
to Schedule A.
It is
All
their
right,
case.
yes, Mr. Talukdar, anything you want to say?
And lordship will kindly grant us 4 weeks time, my lord, to file a consolidated report by the circle officer, my lord. My lord, he will take the assistance.
All right,
of the
they'll
survey.
confine their operations of the factory to Schedule A and Schedule B land.
Schedule A and Schedule B. It is also.
Huh?
Fully running in Schedule A.
What is your locus?
Yes, my lord.
Yes.
Your lordship is correct. Your lordship kindly come to the lead petition, my lord. There are.
Why have you made him party?
No, my lord, he has intervened. My lord, I am restraining myself. If I spell out what is going on, my lord, it will be very difficult for my learned friend.
Yes,
my lord.
Then
It will be very difficult, my lord.
maintain the rest.
Yes, yes. I am not expecting restraint from the, my lord, you know, everything submit, I also submit, my lord. That will come, my lord.
Oh,
Because, my lord, he is.
you both must think about
Yes,
the
yes, my
poor
lord.
judge also. no?
Yes, my lord. Because he is representing, my lord, stronger section of the society. I am
Okay,
representing.
who is stronger? Who is going to make?
I am weaker, my lord. I am a tribal man, my lord. I am coming, my lord, paragraph 59 of the writ petition, my lord. Paragraph 28. That the petitioner has filed wherein the party of the state of Assam, Commissioner, Additional Commissioner, Circle Officer, Revenue, Sri Monsing is pending disposal for the honorable court. My lord, my humble submission before your lordship is, my lord, it is case is not easy case, my lord. There is a order of the honorable division bench.
It's not easy, that's why they have
Yes,
engaged
my
you.
lord. Yes, my lord. There is an order of the division bench, my lord. Particular this plot of land. You do one thing, you, my lord, evict all these persons, my lord. Despite the order cannot be carried, there is a specifically said, my lord, in that order, that this is a tribal blank, you evict all the persons, my lord. That fact has been concealed in this petition, my lord. They never mention all these things, my lord. And obtain an interim order, my lord, behind the back of this petitioners, my lord, because another proceeding
So
is.
you want them to be evicted from the tribal land? you
No,
want-
yeah, one point is that, my lord. Now he is arguing for interim order, my lord. What he is arguing for interim order, my lord, that he has allowed to run all the factory. The fact is that the factory is running, my lord. I have given some photograph also. I have given some photograph also, my lord. Full phases running the factory of Schedule A land, my lord. I have already given, my lord. It is Google's map, my lord. Yes, running this factory, my lord. 12/7/2026, all the photograph is available, my lord. He has already learned government advocate has said they have running the factory in Schedule A land. Now they want to grab the land, my lord, in the, my lord, government land by the order of this honorable court, my lord. And my lord, so far relating to your lordship has asking a very good question. How, my lord, Purbanchal Cement can file a petition along with Northeast Frontier Deal? If your lordship go to the resolution of the board, my lord, for Northeast Deal Association page 36, resolution was taken by the Purbanchal on behalf of Northeast Deal. How can it be, my lord? Your lordship kindly go to the page 36. Annex 3, my lord.
Yes.
Northeast Industrial Deal Power extract from the minutes of the meeting of Board of Director Purbanchal Cement held at Register Office at so and so, so and so. On that, they have took the resolution that Rukmal Boro, who is the director of my lord, Northeast Fairdale, can file a writ petition on their behalf. How can it be, my lord? And my lord, minus significant fairly submitted that Schedule A land is the Purbanchal land. Schedule A land has already been run by the factory, by them, my lord. The question of grabbing government land, my lord, this way, my lord. And important thing is that, my lord, I am, my lord, let's say kindly go to the, my lord, one thing, my lord, important. Of my affidavit, my lord.
So, Mr. Chaudhary, what is that you are asking today? What is your problem?
My humble submission is your lordship, if your lordship allowed to take them to run the factory in the government land, they have occupied all the government land.
No, we'll ask them not to occupy.
They have done, my lord. Everything has been done. As in fact, my lord, report has been, I'm very sorry to say, government has submitted the report that which is being given under seal cover, copy given to them, my lord. Your lordship kindly go to the report. Everything is in their control, my lord. Now the circle officer has changed. They have control over the circle officer and do everything is there.
No, but we are monitoring the matter.
Yes, my lord. And my lord, notice in respect of government land is not necessary. There is a division, my lord. If it is 18-2, my lord, notice is not necessary. I am in my affidavit, I have annexed that order also. If you also go to order.
No, that's all right. We'll,
Yes.
we'll hear the matter. Let them submit a comprehensive report. as-
My humble submission before your lordship is not that, my lord. There is a hand in gloves going on between the government and the, my lord, this person. And problem is that, my lord, if he got the interim order, my lord, whole case will not come, my lord, within 2 hours, 1 year, my lord. That is my humble submission before your lordship is that, my lord. And once your lordship is directed to produce the report on seal cover, your lordship kindly go to the, please go to the order, my lord. Copy to concerned person, Purbanchal Cement. How a report which has been asking by the seal cover by the court was given copy to the Purbanchal Cement.
Because the court allowed it.
No, my, before that, my lord. Your lordship kindly go.
On the last date, the court allowed all parties to.
No, my lord. Your lordship, that is 14/2/2023. Lordship, kindly go to the order, my lord. And when the court order has been passed, seal cover order, 14/2/2023. Much before your lordship has said, the copies are to the copy, all the petitioners, my lord. It was never marked to us. Though it is written, it was never marked. And other aspect also, your lordship, I will show, my lord.
Yes.
That is one thing. Then written argument. I lordship kindly go to the, my lord, one thing, my lord. I produce a, my lord, written, my lord, reply. Lordship kindly go to this. Go to the copy. I want to show something, my lord. I am not reading that, my lord. I want to show something.
Why don't you file your affidavit?
I filed the affidavit. In affidavit, everything is there.
This document is.
Yes, my lord. Everything is here. The petition has been there, my lord. Everything is there, my lord. Your lordship kindly come to the, my lord. Page 5. Yes.
Yes.
This land, my lord, the respondent of 5 to the most of the land, it is a government land category detailed. Chart 5 will be the said land fall under the non-cadastral category. Page 5, my lord. And my lord, your lordship go, my lord. This all land. It is next paragraph, page 6, my lord. It is that 130 bigha of land fall under the non-cadastral government land in total is 1 bigha 3 kota, 101 bigha 3 kota. Out of, my lord, 131 bigha. 101 bigha 3 kota is the government and non-cadastral land has been occupied this person, my lord. And what is the sale deed? That is important, my lord. One
So, all
number.
right, if they have occupied, we'll ask them to vacate it. We'll remove them.
There is an order of this, my lord, and they were not interfered by this honorable court, my lord.
All right. All right.
The earlier disorder was not only for schedule and
Your
Yes, sir.
grievance is that they are occupying government land in tribal belt. Is that your
yes,
grievance?
my lord.
We'll
And
take care of that.
as per 18,
Let them identify and demarcate the land.
18, that is important, my lord. My
Yes.
humble service is something different. I want to show this petition is not maintainable because some force hold it has been produced. I can apparent from the record, I can show your lordship just now, my lord, that this hold it is a forged and fabricated. Just give me 1 minute, my lord. Yes, my lord. Your lordship kindly come to the ma'am.
In the meantime, can I just show one document, my lord, order to be.
May I complete, my lord? Let me thereafter, my lord.
Mr. Chaudhary, you reply.
Okay. Yes, my lord. Page 40, my lord. Lordship, kindly go to the sale permit, their document, my lord, Annex 6.
Yes.
At the top, my lord. 16/2003/90 dated 18/9/2003. Have your lordship got it?
Yes, yes.
This is the sale deed between Dhiren Bora and Purbanchal Cement. Then your lordship come page 64. KRS 16/2003/19 dated 18/9/2003. How one permission to sell deed can be executed, my lord? Apparently, this is a false document, and many document is there, and another is that person. Page 144, my lord. Tomorrow, my lord, I force a soil list and my lord occupied the Lotasil field. My lord, can it be possible, my lord? This time. Yes, my lord. Annex my lord, 144, my lord. Yes.
No, you are making very good point, but why are you so angry?
My agree, my lord. My humble submission before your lordship then. These are the tribal people, my lord. They have occupied our land also in my lord. Schedule A land, my land is there. To that aspect, my lord, there are many people land, my lord. I have got the order. FIR has been, nothing has been done. The rubber plantation has been given to the some other person, my lord. That was also occupied. Every person land has been occupied.
So we'll look into this issue.
Yes, my lord. Only thing, if your lordship pass an interim order, Schedule B land, my lord, moment they will, my lord, taken all the land, my lord. That is my fear also, my lord.
Leave the order passing to us.
Yes, my lord. And my lord, one thing
You
is, my
make your
lord, yes, my lord.
submissions, we'll pass.
Another
order.
thing, and my lord, if someone is come with forced document, my lord, his petition is disposed, my lord, immediately, my lord. There is a judgment, my lord. May I show that judgment, my lord?
Yes.
144 and 154, your lordship.
But you should not be angry.
My lord.
You
Yes,
should not
my
be
lord.
angry with
Yes, my
Mr.
lord.
Chaudhary.
Yes, my lord. Be it mentioned that vendor has obtained permission for the plot of land 144 page, my lord. That KR is 6/12/2005/1031, 16/10/2006. Again, your lordship go to the page 154, my lord, 57, my lord. That vendor has obtained the same number, KRS 6/2005/1031, dated 16/10/2006. They have done, my lord, this way, my lord, sale deed has been executed one after another, my lord, 4 sale deed, my lord. That is one of the thing, my lord. I am relying on judgment of the apex court, my lord. Yeah, yeah. Yes, my lord. Lordship, kindly come to the, my lord. Page, my lord. Oh, Chinnaya to. Page 26. Other judgment, I
Mr.
also.
Chaudhary, you want a full-fledged judgment in this writ petition today itself?
My submission is something different. man. Prima facie, the fraud has been committed by the petitioner, that has been proved. I saw 2-3 documents, many documents has there. If a person obtained the interim order by
Right,
prosecution.
you first address the court.
Yes, my
What
lord.
is the locus of your client?
Yes, my
Otherwise,
lord.
we may delete your
Yes, my
client's
lord.
name.
Yes, my lord.
Who is your client? What is his locus?
Oh, yes, my lord. My client, his name is, my lord, Monsing Rongpi, my lord. That Monsing, I am coming to the background of this case, my lord. Monsing Rongpi has filed a, my lord, filed a complaint before the, my lord, circle officer. Then, my lord, circle officer has not passed the order. Then we come to the High Court, my lord. In my affidavit, there is a specific
Complaint saying what?
complaint saying that my land has been occupied by the Purbanchal Cement because civil code has been barred. Under 163 of the Assam Land and Revenue Regulation, civil code has been barred.
All right.
Yes, my lord. As per my lord, section mandate, my lord.
Your land has been occupied by Purbanchal.
Purbanchal Cement.
Which is your land? Show me the document.
The whole factory is running in city.
Show me the document.
Yes, my lord. Yes, my lord. May I read that order, my lord, particular order, my lord? Your lordship kindly allow me, my lord. Your lordship kindly go to the by affidavit of opposition.
No, your affidavit of opposition, where are the title documents?
Yes, my lord. If your lordship kindly go to the title document is available, my lord. I have annexed, my lord, in
Yeah,
that petition also. That gets in, my lord.
Please
In
show
that,
it.
you know, I can produce that or title document, my lord, on next date
No,
also.
we will pass an order today itself.
Yes, my lord. I am coming, my lord. Kindly got to the order. If you don't push on the could look.
Yes.
Yes, my lord. That my lord, your lordship, my lord. That WPC 4761/2021, my lord. Page, my lord, 337,
First of all.
Annexer G.
Mr. Chaudhary, first of all, where are the documents of your client to show that he owns any land in that vicinity?
I have document, my lord, but
Where is it?
there I am not produced, my lord, in there, my lord, and that, my lord, I
Can you
can.
produce those documents?
Yes, my lord. Yes, my, I can produce on next day.
Do it.
Yes, my lord. Yes. Yeah, I have stated in my affidavit in opposition also, man.
That's right, but where are the materials to support
Yes,
it?
man, I shall produce next day after tomorrow.
Mr. Saikia, you are appearing in this case.
Because I have heard on the last occasion and today also that our circle officer is hobnobbing with the petitioner client and all these things are made. So I called all the concerned officers yesterday. And that's why this 4 weeks time, if required, the DLS and the revenue department will, if subject to what lordship says, we are agreeing that if lordship appoints a commission also, everything, the right thing should be placed before this honorable court.
Right.
I have gone through that circle officer's report also yesterday, and it was a little bit vague in nature. So the DLS, the whole authority will be engaged there for 1 week or 10 days, and they will come with a comprehensive and correct report before this honorable court. That is what I would like to, because some officers are being tarnished by my learned friend, although he is angry, he is saying that he is hobnobbing. So this bears a very bad impression to the state government's officials. We do not want that.
Right, right.
So whatever, I do not know what is the exact case also, but the correct report should be placed before this honorable court. So this was on my only limited thing, and we are also open if lordship appoints a commission there. That will be subject if we submit a report.
The court has full trust in the system.
Yes,
Why should
Lordship.
we appoint a commission?
No, the thing is that whole area,
Hmm.
it is that Amsang area basically. That area, there are some disputes regarding the revenue land and the forest land. And lordship knows is. Now he is saying tribal. Okay. So that area, there are certain areas where there is some dispute. That is why a PIL was lodged by the Honorable Court Suomoto for encroachment in the Amsang area, wildlife sanctuary. The revenue gave one map, the forest gave another map. Ultimately, the general survey of India was engaged to give the proper report. I think that kind of situation may arise here also. I do not know.
Right, so as the court is looking at it.
Exactly, Lordship.
The petitioners are saying that they have acquired some land by means of some registered sale deeds and set up the cement plant over there, which is, they are running it, and they are supporting employment to number of persons. This has been an ongoing operation.
Lordship.
So suddenly the circle officer comes and seals a part of the factory by projecting that they are encroaching government land, which may be correct, But the fact remains that there is no written notice indicating which part of the land is government land, etc., etc. Now, the court had called for a report, making it clear that you also show cause as to why an interim order as prayed for should not be granted. The report has come. The report is before us. I agree with you that this report is, it hides more than it discloses.
Yeah, exactly, Lordship.
But then this can be rectified by the procedure. You
Yes.
said, a more comprehensive exercise.
Exactly, Lordship.
That
The
certainly.
DLS officers will get
certainly,
involved now.
Let them do it.
Yes.
Let them do it. If at the end of the day it is found that the factory has been set up over government land or there has been encroachment, the remedy will be to remove the encroachment.
No
ask
issues at
them
all.
to vacate. But till all these things are done, till there is something in black and white, which either shows that they have encroached on government land or these sale deeds are forged or whatever. Why should the operation of the factory be stopped?
I think it,
That's only, that is it.
let us, no, in that case, my submission, well, let the status quo be maintained. If it is going on, let it go. If it is already stopped, that can be one way, because we'll take 10 days time, not more than that. Or Lordship may fix the matter after 2 weeks. In the meantime, we'll file the report.
So that's all right, but for now, what has that got to do with operation of the factory?
That
Either
is-
they are encroaching land or they are not.
If they're running it, Lordship, let them run. And if they are not running it for a long time, then let it stop. That is why my submission is that status quo order can be passed.
No,
If
that
at
is-
all it is required. If
that
they are
is-
running, they will not ask for,
You are asking the court to pass an order not to run.
no.
Then-
Status quo may be maintained. Whoever, if they're running, one side is saying that they're running. The other side is saying, I do not know what it is.
There are two plots. Over one plot, there is a blockade. One part, my lord, we are buying the raw material from outside and operating in the part where it is with us.
Which part you are operating? A, schedule A. And the blockade is on
No,
schedule B.
part of A, part of B. It falls both, my lord.
So
But
10
that-
days will not make any difference,
No, no,
Lordship.
it will make a lot of difference, my lord. We have to recover, end of the day, my lord, it's a
All right,
business.
Mr. Saika, are you appearing in this case?
From today onwards, I think I should appear. Because if
My lord,
the
can I just point out one?
the
paragraph,
revenue
my lord?
senior officials are also getting involved now, because we do not want any bad name, because we are removing lots of enforcers all across the state. So if one area is not being done properly, Lordship, then that will bring bad name to the
All right,
government.
you carry on with your exercise.
Yes, Lord.
Carry on. There is no restraint from the court. You carry on.
Whenever I am required, Lordship, I can, otherwise, Mr. Borpujari is here for,
Government takes the instructions.
but he is directly alleging the governments are hobnobbing. That is creating problems.
I don't know, not my lord. That instruction taken on tomorrow, my lord. Because
No.
So he is angry on petitioners and government both. That is complicated the issue.
No, I am not, I am on, that the correct facts should be placed before this honorable court.
That's right.
I don't need.
All right. So,
My lord-
yes.
I leave there everything to this honorable court, but we are on job, Lordship.
Would go, Lord.
All right, Mr. Chaudhary, I think.
What I was trying to draw your lordship's attention was the argument which my learned friend has made, my lord. My lord, it was considered by this honorable court. Please have a look at order dated 2/6/23, two paragraphs, my lord. Now, the argument which my learned friend has made today has already made on 2-3 occasions, and it was rejected. And he has not preferred any appeal. Please come to order dated 2/6/23, para 10. Paragraph 10. For the purpose of, sorry,
Yes.
for the purpose of interim order, this court is disinclined to take cognizance of the stand taken by respondent number 5, that is the client whom my learned friend represents, that the land documents produced by the petitioner in fact false for two reasons. Firstly, no competent court having jurisdiction has declared the documents to be forged. Secondly, without a declaration being available as to forgery of the said document, this court in exercise of jurisdiction under 226 of the Constitution of India would not enter into a disputed question of fact. So regarding forgery, my lord, this argument was advanced and it was rejected. Now kindly come to paragraph 11, my lord. 11, no, I got it.
kindly read para 9, my lord. His pair for
Yes,
government
yes.
and also rejected.
Yes, para 9, my lord. Yes, I'll read para 9. Very well.
That was also rejected.
Insofar as claim of respondent number 5 is concerned, to the effect that land of the respondent number 5 was illegally usurped by the petitioner to set up the factory, there can be two inferences which can be drawn. Firstly, that the petitioners were evicted from tribal land protected under chapter 10 by the circle officer in guise of removing them from government land. The second possibility is that instead of evicting the petitioner from tribal land, the circle officer used the power under Rule 18(1) and 2 of the regulation to evict the petitioners from purely government land. Under both these circumstances, if respondent number 5 has any claim of ownership of land allegedly belonging to him, it would not be open to the respondent number 5 to hesitate the said claim in a writ petition filed by the petitioner as if he was making a counter claim. In the considered opinion of the court, any claim which the respondent number 5 might have against the petitioners has to be adjudicated in an appropriate forum. So my lord, my learned friends.
Next line, my lord. Next line, read, my lord. That is important.
Okay, let me read. It is not the case of the circle officer that he was evicting the petitioners from the land under tribal bill. If that be the case, then circle officer would have given a notice to the petitioner as envisaged in law, and the provisions of Rule 18(1) and 2 would not be available to the circle officer. Okay. Now, my lord, so far as all the merit of the concern is a different aspect. But so far as his locus is concerned, my lord, this point has been dealt with by the learned single judge of this honorable court. And this order has again finality because till that he has not, my lord, filed any writ appeal against this order. Both the issue, forgery and his locus, my lord. Therefore, my lord, I do not know. I think it is intelligible. It is quite intelligible what is the meaning of this order. On merit, I'm not speaking on merit. on his locus. So why is he appearing again and again when the honorable court has said you can't appear? That's all right.
Notice is not required, there is a judgment matter of the division bench, that is why I am.
Mr. Chaudhary, I think I have heard submissions. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. R. J. Das, learned counsel appearing for the petitioner. Also heard Mr. D. Saikia, learned advocate general Assam, assisted by Mr. R. Bopachari, learned standing counsel, revenue department, appearing in this case on behalf of the respondent numbers.
All the respondents.
All respondent numbers 1 to 4. Mr. NNB Chaudhary, learned counsel, is present on behalf of the respondent of 5. Full stop. The writ petitioner herein claims to be running a cement factory over a plot of land described in Schedule A
And B.
Schedule A and B. Full stop. According to the writ petitioners, the land described in Schedule A is owned by the petitioner numbers 1 and 2, whereas the land described in Schedule B is owned by the petitioner numbers 3 and 4. Full stop. Moreover, as per the projection made by the petitioners council, an additional area of 20 bighas, 4 kathas and 9 lechas of land is under lease to the petitioners numbers 1 and 2, in respect of which revenue is being paid regularly to the government. Full stop. The grievance of the petitioners is that on 28/4/2023, the circle officer of the jurisdictional circle officer, that is the respondent number 4 herein, had arrived at the factory of the petitioners and put a seal partly over the Schedule A land and partly over Schedule B land, thereby compelling the petitioners to suspend the operation of the factory. First up, aggrieved thereby, the instant writ petition has been filed, inter alia contending that the impugned action on the part of the respondent number 4 was not preceded by any notice, or nor was the petitioners given an opportunity of showing cause. First up, as such, the impugned action is wholly arbitrary and without the sanction of law. Full stop. Mr. K. N. Chaudhary, learned senior counsel appearing for the petitioners, have vociferously argued that the petitioners are running the cement factory over land purchased by them based on registered deed of sale, and in the process are directly supporting as many as 250 employees, while indirectly supporting the livelihoods of nearly 500 other persons of that vicinity. Full stop. Notwithstanding the full stop. It is also the submission of Mr. Chaudhary that the petitioners are paying tax.
Yes.
To the government, tax including cess and other duties to the government
To the extent of 85 crore.
to the extent of rupees 85 crores per
Annually.
annum. However, due to suspension of the factory, the entire operation has come to a standstill, thereby causing serious prejudice to the interest of the petitioners. First up. It is also the submission of Mr. Chaudhary that his clients have not encroached upon any land belonging to the government. First up, Mr. Chaudhary has, however, disarmingly submitted that in the event it is found that any government land is under the occupation of the petitioners, his clients are ready to give an undertaking to vacate the said land forthwith and also face any proceeding in respect thereof as may be permissible under the law. subject to a proper demarcation of the land being carried out by the authorities, full stop. The issues raised in the writ petition have been dealt with in details by the order dated 02/06/2023 passed by this court, including the contention of the respondent number 5 to the effect that the sale deeds relied upon by the writ petitioners are forged deed and that they were in occupation of land falling in government land falling in tribal belt. As such, the circle officer had the power to evict them under rules 18(1) and 18 and (2) of the Assam Land and Revenue Regulation 1886 without serving any prior notice. Such contention of the respondent number 5 was evidently declined by the learned single judge. Full stop. Thereafter, by order dated 27/6/2020, thereafter, declined by the learned single judge, and a report was called for from the circle officer in seal cover. Indicating the demarcation of the land occupied by the petitioner's cement factory. Full stop. Consequently, a report of the circle officer dated 14/7/2023 was presented in seal cover. Full stop. Taking note of the observations made in the subsequent order dated 27/6/2023 passed by this court, wherein it has been categorically observed that since the petitioners' counsel had submitted that the industry of the petitioners have been closed down, and there is a prayer to allow the factory to resume its activities, the respondents were asked to show cause as to why an interim order passed earlier should not be continued and should not be permitted, should not be granted, permitting the petitioners to operate the factory. First up, since the learned counsel for the petitioner has pressed for an interim order, and considering the fact that the report of the circle officer in the meantime was available, though in a seal cover, this court had passed order dated 7/8/2023, directing that all parties be furnished with a copy of the report dated 14/7/2023. First up, on a careful reading of the report submitted by the circle officer on 14/7/2023, I find that the following reflections have been made in the said report, which are quoted herein below, double tick to double tick. Full stop. From the above, from the report dated 14/7/2023, it is evident that due to absence of a Venn Dyke map for the entire area of land falling within the ambit of the petitioner's cement factory, the circle officer could not give a concrete report as to whether the petitioners are in fact in occupation of Sarkari land falling within the tribal belt. First up, in view of the allegations and counter allegations made at the bar, raising a doubt as regards the bona fide of the officials from the revenue department in their attempt to present the correct facts before this court, Mr. Saikia, learned AG Assam, has appeared and submitted that correct facts pertaining to the identity and occupation of the land will be placed before this court within 4 weeks after carrying out a comprehensive survey of the area by engaging the relevant officials. As such, 4 weeks time be granted for the purpose by this court, full stop. Mr. NNB Chaudhary, learned counsel for the respondent number 5, has vehemently opposed the prayer made by the petitioners for allowing them to operate the factory. But on the other hand, it is his submission that the factory has all along, the cement factory has all along been under occupation, and therefore no interim order is prayed for, is called for in this case. After taking note of the facts and circumstances of the case, as well as the projections made in the bar, this court finds that there has been a cement factory in existence in the area where the disputed land falls in, and the said factory was apparently running its operation since the year 2008. First up, although it has been alleged that on 28/4/2023, the respondent number 4 has sealed a part of the land, thus compelling the petitioners to shut down the factory. There is no formal order issued by the said authority directing the petitioners to refrain from operating the factory. Full stop. As noted above, if after a detailed survey of the area and on demarcation of land, it is found that the petitioners are occupying part of the government land, then remedial measures can be adopted in this case. However, until and unless such an exercise is carried out and completed, it will be wholly unjustified to shut down the operation of a factory which is not only generating employment, but is also generating revenue for the government. Situated thus, the following orders are passed. The respondent authorities shall carry, the respondent numbers 1 to 4 shall initiate all actions to carry out a detailed survey of the land claimed to be under possession of the petitioners, including the Schedule A and B land. In doing so, they shall also examine whether the petitioners, whether the sale deeds relied upon by the petitioners are genuine and have been executed by following the due process of law. On completion, number 2, on completion of such a survey, a comprehensive report be placed before this court within 4 weeks. Full stop. Until such time, the aforesaid exercise is completed, the respondents shall not restrain the operation of the cement factory of the petitioners without serving any prior notice upon them. This direction is, however, subject to the condition that within 2 days from today, the petitioners furnish a written undertaking before the respondent numbers. Before whom? Respondent number?
Before the certain officer.
No, let it be before the deputy commissioner.
Deputy Commissioner.
Respondent number?
Respondent number 2.
Respondent number 2, to vacate any Sarkari land and oblique land falling in tribal belt, if the same is found to be in illegal occupation under the petitioners. Let this matter be listed again after 4 weeks.
Let me say over Schedule A and B land. The
B is the
operation.
government land. No, say like that.
Schedule
Over
A and
Schedule
B
A and B land.
B is the government.
Operation.
Ah.
Will operate.
shall not restrain the operation of the factory over Schedule A and B land.
They asked because they are wanted to take all
Mr. Chaudhary, you file your affidavit. The battle is just begun. It's not over.
No.
Hmm.
Can I fix it? Can we also fix it?
After 4 weeks. This is the- Yes. So there is one more matter.
13.
Well, not in this case. The petitioner is, my lord, assailing. Certain
What- this
serious.
has been listed for orders today. What order?
Not for orders, actually, my lord, I was praying for I will be praying for an interim relief, my lord, because earlier notice was issued, then affidavits have been filed. On a short point, my lord. My lord, what had happened in this case, my lord, in a very short compass, there is a road, the width of which is 4.5 meter wide. Now, my lord, in front of the building, the wall has been taken back by about 8 feet. Therefore, the road becomes, my lord, 8 meter wide road. That is what has happened in this case. And the minister concerned, my lord, in his son's case, he constitutes a committee and gives permission. And the permission applied for on 1/9. My lord, on 3rd, a committee is constituted by the minister. 5th report, 6, 7, 8 holiday. A 6, 7, 8 holiday, my lord, 10 permission given. 21-story building in Guwahati city. This is the allegation, my lord. And my lord, in an earlier litigation, a report was submitted by the GMDA regarding the width of the road, where the average width is between 4.5.
Mr. Chaudhary, I won't take up this matter for some personal reasons. Let this writ petition be listed before any other bench without me. Yes. I have been appearing for this builder in many matters.
Register will list it before the appropriate bench.
In view of the urgency expressed in the matter, register to list this case before the appropriate, before any other bench in the next week.
Deep level.
In this case, my lord, respondent number 4 has filed affidavit in opposition yesterday, my lord, and we have received at about 3 p.m. So we have to file reply against that affidavit. Some time, just yesterday.
My lord, I am appearing for the respondent number 4, my lord. I have filed a IA, my lord, praying for modification of the vacation of the interim order.
IA we did not receive.
No, IA only affidavit file for an IA.
You will file reply to it, my lord.
Achha,
We'll file
Mr.
report. Shall I have
Bora
the-
Learned Council appearing for the respondent number 4 submits that an interlocutory application numbered and registered as
No number, not a number.
No, registered, my lord. It has been registered.
Not yet registered.
Registered, my lord. I have got the registration number. IA civil number 2335/2023.
2335
2023.
2023 arising out of this writ petition has been filed on behalf of his client only yesterday,
Yes, sir.
but the same is not on record. Mr. Bora therefore seeks posting of the IA along with the writ petition. Mr. Sinha Learned Counsel for petitioner has confirmed receipt of the IA, but seeks a week's time to file objection. Mr. N. Goswami and Ms. G. Hazarika are present on behalf of the official response. In view of the prayer made at the bar, let the registry list the IA along with the writ petition after a week.
After 2 weeks, my lord. My
After
lord,
2 weeks.
after 2 weeks, my urgency is there. They have.
Interim order pass, I shall continue.
Interim order passed earlier to continue until further orders.
Time being matter, item 8.
Yeah, please, my lord. The engaged council is still on legs, my lord. So can it be taken up on next week, my lord? Any day, my lord.
On the prayer of learned counsel for the applicant, this matter stands adjourned for a week, list again after a week.
For hearing, item 14.
My pleasure. So the standing council, Mr. Ganguly is on legs, and the learned senior may start in the meantime. He will be.
Yes. Yes, what is the matter?
Yes, my lord, by your lordship, order dated 14/6, 50% of the gratuity has been ordered to be released. So now, only point to be decided is whether pension and the leave encashment be released or not. So my lord, let me submit on the point of pension first, which is in fact, my lord, as your lordship will appreciate and knows, is the lifeblood of an employee or all the employees after long service in an organization where pension rules and regulation is in vogue. So this is most important. And in your lordship,
Just for me, just for me. Yes.
so my lord, if the lot of the life is taken away, your lordship will appreciate and know.
He was dismissed, he was dismissed from service.
He
Not
has
like-
been removed from the service, not
Removed.
dismissed. There are three types of punishment:
Hmm.
removal from service without disqualification, and another is dismissal from service with disqualification.
Hmm.
He has been imposed with the punishment of removal from service without any disqualification.
Where is the order? Where is the order of removal? Order of removal from service?
Order, my lord, as a matter of fact, this order order has been long past, and this order has been challenged by a writ petition, including inquiry proceeding. That writ petition has been dismissed for whatever be the reason. Against that, appeal has been filed before Honorable Division Bench, presided over by Chief Justice. There ultimately it was decided that this order, the writ petitioner will not challenge. Instead, writ petitioner will file a supplementary affidavit only for release of the terminal benefit. That order has been passed by the then Chief Justice Ajit Lamba and other judges. And after that, the matter came up before Honorable Justice Dhulia. And after hearing me during the corona period virtually, Honorable Justice Dhulia has told that since it has not been challenged about the release of the terminal benefit, let the matter be remanded back to the single bench and let it be decided whether this will be released or not. In the meantime, it has been about the release of the gratuity, a writ petition has been filed only for release of the gratuity. And the then Honorable Justice Sudhanshu Dhulia, he has passed an order that 50% of the gratuity will be passed, giving detailed reason. On that basis, your lordship has been observed that why other 50% should not be released. So my learned friend, Mr. Ganguly, was fair enough to admit that yes, another 50% deserve to be served. And your lordship has passed the order on 14 June. This is the background. So immediately at this moment, removal may not be looked into because already this is the finality. So
What is the language used in the order of removal? That's what I.
removal, that language is he has been removed from service. That's all and nothing else. He has been removed from the service. And I can place this regulation. One moment, my lord. If your lordship kindly, I have given the regulation, discipline and appeal regulation, wherein it has been specifically Punjab employees discipline and appeal regulation. If your lordship kindly see page, I have given that regulation in a binding form. That will make a position clear. Yes, ma'am.
So when an employee is
Yeah, but-
removed from service,
One minute,
there
my
must
lord.
be some provision. in
Page
the-
238, page 238. Kindly see major penalty. Page 254, page 254 of the discipline and appeal regulation, Punjab National Bank discipline and appeal regulation, wherein it has been mentioned major penalty. May I read out?
Yes.
Reduction to a lower grade or post, compulsory retirement.
My lord, I am unable to follow because my copy doesn't have any paging. I don't know where my learned senior friend is reading from.
It
I've
is
been-
there.
I've been given this, but
It is not given, it is their regulation, my lord. To an officer employee appointed under a contract and officer employee abolition of the post, my lord. Next, 239, removal from service which shall not be a disqualification for future employment. This punishment has been imposed. Removal from service which shall not be a disqualification for future employment. This is your regulation.
sir, I am unable to follow because my copy, whatever is.
It is
relied
their
upon, has to be
regulation, my
paged, my
lord.
lord. How can I follow, my lord? He may read anything, my lord. I
It
don't
is
know.
their regulation.
No, no, no,
see
their
the copy.
regulation, no, this paper book, you have not given.
I have given to
No
him
paging.
paper book, but maybe this regulation has not been supplied. Maybe it is missed. So, but this is their regulation, so they can see it from my copy. If it is, I am submitting something wrong, it is their own regulation. Can they deny it,
No, no,
my lord?
Mr. Sarvadi,
Yes, my
you
lord.
are a very senior.
Yes, my lord.
Person.
I know somehow or other, junior have missed that.
If he complains, then what is the option for the court? He is complaining about it. If you are relying on a document.
Regulation 4. পাঞ্জাব ওটা হয়তো আপনাকে দেয়া হয়নি আমি পেয়েছি কিন্তু তো দেয়া আছে তো
Regulation 4.
হ্যাঁ পাঞ্জাব ন্যাশনাল ব্যাংকে অফিসার এমপ্লয়িজ ডিসিপ্লিন এন্ড অ্যাপিল রেগুলেশন
Pension.
এটা তো পেনশন এটা পরে চলে যান পরে 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 চলে যান এটা সার্কুলারের পরে চলে যান এটা দেওয়া হয়নি আপনাকে
Oh, this, how do we go on for final decision, disposal of this writ petition today?
Possibly, my lord, in his notes of argument, that regulation has been missed. I was under impression, my lord, that this is their own regulation. How they can deny it? I can give him this copy to him just now, he can say, and say it is not.
That is for you to sort out with the,
I understand, but maybe I was,
No, I would have adjourned it straight away, but only thing that is coming in the way is you are probably coming from outside.
Calcutta, my lord.
But if the hearing doesn't become possible, then we'll have to adjourn it. Otherwise, it would have been adjourned by now. But how do we proceed? Because if this is the only regulation that fine, but if you refer regulation after regulation, then it will be.
Yeah,
difficult.
only this regulation has not been filed to them, the all other has been provided.
Have you given him this?
Here it has been filed.
Have you got this
It
copy?
is there.
Yes,
there is no
but
paging.
this particular copy was not
This
there.
regulation, they have not paged.
That regulation, because it is their own regulation, I thought that they will accept it.
No,
I can
that's-
accept it
that's
when I
not
provided
the
I
case.
see.
I can place this copy, he can go through it.
Extra copy that will do.
নেই আমার কাছে আমি তাহলে জেরক্স করে দেব just now you see it.
Are you here tomorrow?
No, my lord, I have a medical checkup tomorrow. So in that case, my lord, I leave it to your lordship. What
No,
can be-
there is nothing to leave. If he complains, then.
Ah,
we'll drop the
right,
hearing.
right. But I can give the copy, but now he can see.
As I said, it is for both of you to sort it out. We cannot, I cannot, the court cannot force
I
him.
can take a copy, my lord, but how will I then my learned senior friend will have to, because he doesn't have an extra copy. That is, I have no difficulty.
And ideally, my lord, this sort of a
Shall I
compilation
hand
should be
over
painstakingly-
here, just 2 minutes time, he will give a copy and give it for the first copy?
Make a photocopy.
Yes.
Why haven't you given a copy? You don't know,
Senior, he himself, all this arrange all these things, I don't know what he came for the. My apology, Lordship, I will do it.
Can you give it to him?
I'm giving it. Well, in the meantime, may I continue with this pension regulation or then I can say about your lordship query about the what punishment has been imposed. Then I can. In the meantime, my learned friend has pointed out regulation 22 of the pension regulation.
Yes.
Regulation 22 has been, I have mentioned at Punjab National Bank pension regulation.
Yes.
174 and relevant page is 187, wherein the head note is forfeiture of service
There is no pagination anywhere.
in that pagination is there, my lord. I am giving.
Do you have this? Do you have this yourself?
Yes, I have by hand, I have given the pagination.
Which page? Page number?
Page number 174, Punjab National Bank pension regulation. Page number 174
Yes.
and then 187. Then 187, my lord, where this regulation 22 has been mentioned. 124 or 187, my lord,
Yes.
for future of service. For future of service, it has been specifically mentioned that if this punishment has been imposed, there will be forfeiture of service and consequently pension will not be paid. This is the regulation, no doubt about that. But what has been snatched away by this regulation has been given back to the employees by regulation 43 to 49. That 208, my lord, of the your lordship. Pension regulation 174 and that 208, my lord. Kindly see 208.
Mr. Kejriwal, you are appearing, you are waiting for which matter? What is this matter? What? So we'll do it next week. Yes. Next week we'll do it. Yes.
208, my lord. Regulation 43. 208.
Regulation?
43 onwards.
Hmm.
May I read out, my lord?
Yes.
The competent authority may be ordered, it will not be by order in writing, withhold or withdraw a person or a part thereof, whether permanently or for a specified period, if the pensioner is convicted of a serious crime or criminal breach of trust or forgery or acting fraudulently or is found guilty of gross misconduct. This is regulation 43. So none of these category the prisoner has come. That will come subsequently. I am coming. Neither there is a criminal breach of trust or criminal offense, nor there is a grave misconduct. And grave misconduct has been defined in this regulation. That later I am coming. Now, regulation 44, my lord. Where a pensioner is convicted of a serious crime by a court of law, action shall be taken in the light of judgment of the court relating to such conviction. This is also not applicable, my lord. Pensioner guilty of gross misconduct. In case not falling under regulation 44, if the competent authority consider that the pensioner is prima facie guilty of grave misconduct, it shall, before passing an order, follow the procedure specified in Punjab National Bank Officer Employees Discipline and Appeal Regulation 1976 or in settlement as the case may be. Now, my lord, kindly turn the next page, wherein other regulation I will come later, wherein
Page 209. Next page.
Yes.
The expression grave misconduct includes the communication or disclosure of any secret, official code or password or any sketch plan, model, article or notes, documents or information such as is mentioned in section 5 of the Official Secrets Act, which was obtained while holding. This is not the case here.
No, it includes.
This is there, but in the petitioner case, this is not the allegation. Allegation I am coming later on. Now my submission is that the expression grave misconduct includes the communication or disclosure of any secret, official or password or any sketch or plan, model, article, notes, document or information such is mentioned in section 5 of the Official Secret Act. It is not the charge against the, my learned friend will agree, it is not the charge against the writ petitioner. Writ petitioner's charge is something else. Now, next, my lord, it is further clarified. Office in the bank so as to prejudicially affect the interest of the general public or the security of the state. The security of the state is not affected, general public. Here, my lord, charge sheet has been issued for him for releasing the subsidy government has given to the bank to the farmer. And condition was there in the bank, the subsidy should be released along with the loan. Along with the loan, this has been given 3 years back. But somehow or rather, neither loan has been sanctioned, nor subsidy has been released. But banks' norms is the subsidy will be released along with the loan. In the meantime, my lord, pressure come from the government that subsidy should be released to the poor farmer, whether loan release or not. In that respect, my lord, video's letter is also.
Sarvadhikari,
Yes, ma'am.
would you please indicate what is your submission? What is your?
My lord, my submission is that pension should be paid according to this regulation, bank's own circular, and on the basis of several Supreme Court and High Court judgment. That I have included.
So how do you circumvent or overcome regulation 22 forfeiture?
Regulation 22, I am overcoming by this subsequent regulation. Let me place this regulation and then bank's own circular, as well as the Honorable Apex Court judgment and the judgment of Honorable Justice Ajit Lamba, Chief Justice.
Ajit Lamba.
Huh.
Ajay Lamba.
So that's why some time will be taken. That is the whole thing.
Will you be able to complete today?
I am trying, my lord.
Then he will need some time to reply.
He will take some time. Possibly, if I can complete today, I shall try to, because now it is 2:25. By another 1 hour, I hope I may be complete.
Then we have to shift it to another day.
As your lordship please, but in that case,
Have you prepared the written argument? Is there a written note of argument?
yes, it is there already. It is first. It is already there.
Have you received
Yes.
it, Mr. Ganguly?
Yes.
And your part?
But I have not prepared, but I'll prepare. If it goes to another day, my lord, I'll prepare a short synopsis, because the central issue, my lord, is whether regulation 22 will be applicable with full force. Because there were 2 questions. One question was whether the payment of gratuity. That question, your lordships have rightly observed that the question of
So he has said that the gratuity amount has been ordered.
Ordered to be released.
yes,
But it has not yet been released.
Why it has?
No,
not been released?
50% has not yet been released in spite of your fair submission.
no, I think he's talking about the balance 50%.
Balance 50%, it has not yet been
I'll
released.
take up the matter.
Previous 50% on the basis of the judgment of the Honorable Justice Dulia, it has been released. But from the 14 June, when 14 June your lordship passed the order in presence of my learned friend, and on his very fair submission from 14 June till today, no gratuity amount has been released. So I am entitled for the interest, my lord. So I am entitled for the interest from 14 June.
What will be the amount? 50%? What will be the amount?
Total gratuity amount was 10 lakhs. Now it is 20 lakhs, but when my learned friend, when writ petitioner retired, then it was 10 lakhs. Subsequently, it was amended, but with prospective effect. So 5 lakhs he will get from 14 June till the bank release it with interest as per section 3 and section 4 of the Interest Act, your lordship knows. In spite of
There's
your
no direction to
lordship
pay
order in
interest.
presence of my learned friend.
In the order, there is no direction to pay
No,
interest.
but,
There was only there was only a lordship's observation, rightly, my lord, that the aspect of gratuity has been settled by the apex court. Now, I possibly wouldn't urge a point which has already been settled by the apex court.
What do you have to say on his argument that 22 does not come into play here?
My lord, 22 is the only provision which comes into play here. That is the crux of the question, my lord. Because 43, 44, 45, 46 are irrelevant. to
Some
the-
more regulation are there. I have only submitted a few. Let me place the entire regulation. I told 43 to 49 and then some other regulation. And bank's own circular is there, my lord. That pension has to be released. Why? Bank's own circular.
The problem.
Not only that,
I've
not
gone
only
through-
bank's bank's own circular. So if I be permitted to place this, then matter will be clear one by
No,
one.
what I am asking is, let them first pay the amount. We will post
I
it.
leave it to your lordship.
I'll instruct them.
Let your junior be there. Let them, if they don't pay, then we'll drop contempt against the
We'll do
officers.
the needful.
Well, my lord, by drawing contempt, I will not be benefited. I want money, my lord. I am hand to mouth.
No, the
So let
gratuity
it be,
question
yes,
is
let
settled.
them pay with interest from 14 June till they release. Because as per section 3 and 4 of the Interest Act, it is the bank is bound to pay the
So,
interest.
Mr. Dharmaragari, please
Huh?
tell us very clearly,
5 lakhs. 5 lakhs already he received.
this matter cannot be concluded today.
No.
In any case, it is going to another date.
Yes.
Would you want the matter to be adjourned now and we ask them to, we'll post the matter on Monday for him to obtain instruction and submit. Monday you need not come, your junior can appear. And
But
after that,
argument I have to complete. My junior cannot do the argument.
no, not for argument. On Monday we'll post it so as to.
Whether this amount will be released or not.
Then you inform him a date, we'll fix it on that day. For hearing, making it the first
My
item.
lord, my two submission. One submission is, my lord, if it can be fixed it in the first hour, is subject to your lordship convenience. Otherwise, because then it will be possible for me to go back on the same day. That is the one difficulty. In the evening, I will come. If it is taken up on the first half, it will be, I will be there.
All right, can you
Alternatively, my
indicate,
lord, if it is done in a virtual mode.
can you indicate a date convenient to you?
My lord, it will be August, it may be say first week of September.
So you argue virtually?
If your lordship permit, I can argue virtually. That will be great privilege to me, my lord.
But you have to make a request when the matter is. released.
You can make a request. Yes. That will be better. I need not come then. And my junior will be place all this regulation. But it will be better. I will ask my time. If I myself make yourself present and if I can, then it will be more forceful. If I place this document one by one. So you can fix any date. I shall try to come. So by plane, I will come and by plane. So my only
Mr.
request in that
Sarbadekari,
case,
Learned Counsel
that
for
it will be in the first half.
has
If
appeared
it
and
is
submitted
not
that
inconvenient, well,
despite the order dated 14/6/2023 passed by this court, the 50% of gratuity amount as per direction of this court has not yet been paid to the petitioner. As such, the petitioner's counsel has prayed for payment of interest on the aforesaid amount due to delay in release of the amount. Mr. A. Ganguly, Learned Counsel appearing for the bank, on the other hand, has submitted that as per instructions received by him, the amount was supposed to be released sometime back, and therefore he be granted time till Monday to obtain instruction.
Can be on 17th, 17th. 17th or 16th minutes. I will try, I will do the
21st, 21st to obtain instruction as to how soon the amount can be released. In the meantime, this matter has come up for final hearing today. But when this writ petition was taken up, Mr. Sarbadekari submits that it may not be possible to conclude the hearing in the matter today. As such, if another date is fixed by the court, then he be given the option to address the court through virtual mode in case he is unable to
Grateful.
appear
If I am unable to come, I will do it virtually. Alternatively, I shall try to be
Unable
present.
to come
It
to
will
the
be
court
my privilege and pleasure
physically.
to appear personally before your lordship.
The aforesaid submission of Mr. Sarvadikari deserves consideration by this court for two reasons. Firstly, he is traveling from Kolkata for conducting the hearing of this case, and the petitioner is not in service as on date, and therefore there is urgency in the matter.
My lord.
Full stop. Be that as it may, until the order of this court is complied, until the order dated 14/6/2023 passed by this court is complied with, the question of hearing the respondents may not arise in this case. As such, and on the request of Mr. Ganguly, this writ petition is directed to be posted again on 21/8/2023 as a fixed item in the orders column, so as to enable the learned counsel for the bank to produce compliance report of the order dated 14/6/2023. Full stop. Subject to compliance of the order of this court, a fresh date for hearing of the writ petition will be notified by the registry. This is the case.
There only one request, my lord. I have been given in this condition without any prejudice, newspapers.
Mr.
that
Ganguly,
is,
do you think you should involve the judge with all these things?
Don't think so, but because of these reasons, the hearing.
I
gets
have
delayed.
given you in binding, only that one is
In the
not
meantime,
binding.
The petitioner's counsel may furnish a complete set of
তুমি আরেকবার
documents
bind করে
along with
দিয়ে
written
দিয়েছেন,
argument
আপনি আমার নিয়ে bind
filed in this case, so as to enable the respondent's counsel to file his written argument
Well, fine.
before the next date fixed. Let this matter be listed accordingly. Please tell him to do this much has to be done. All right.
তুমি ওই ফাইলটা আমাকে
Look,
দিয়ে
in
দিয়েছো,
item
ফাইলটা?
8, my lords, I believe it was mentioned, my lord, in my absence.
What is there in item?
No, there was an IA for stay vacating. This is a surface I matter lordship had taken up, my lord, Mr. Chamua was there.
Officer is division bench 1.
Otherwise, my lord, it relates to my lord, refund of his amount, and he was asking for this. This is that matter, my lord, Mr. Chamua had appeared the other day, and regarding whether he had any vested right or not, that issue, my lord, my lords.
Are these cases to be taken up by DB1?
It will be before the division bench.
Can you mention, tell the bench section?
My lord, my only submission is, can it be taken up if any date is fixed as to your lordship convenience in the first half? Then it will be very much good.
Please tell your junior. to remind-
Junior, he will remind your lordship on that day so that I can do the job, and by the evening price I can go back. Grateful, my lord, grateful. I'm grateful for giving me this
Yes, yes.
advantage, my lord.
So what time is the flight?
Today I have booked at 7, and next time, because 7 it will be too late, my lord. I will reach there 8, then from there I will stay at South Calcutta near Raspberry Avenue, so it will take 1 hour. Although my car will come, but even then.